when we wake up.
A compilation of statutes for us, rules and research materials.
Yes.
That has everything.
You've got compilation of documents from the Ejection Commission also.
Sorry? Yes.
Sena, I've had this.
Two of our convenience compilation. Compilation of documents in legal 3.5.
Para 15 can be taken from several compilations.
Para 15 is there. Data in your return submission, para 3.2.
And also para 9, Lordship may kindly see. Para 9 at page 5.
It will remain the same.
Change. Para 15 will remain the same in all these compilations.
Correct.
The gloss on para 15 may change depending on what you're reading.
Depends how you
But the
look at,
original.
how you read and how you look at.
That's correct.
No, actually, I have the copyright.
All right, we'll read paragraph 15.
Now, see, when the commission is satisfied on information in its possession,
One minute.
is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The Commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the Commission shall be binding on all such rival sections or groups. So let me, put forth a situation where there is no dispute as far as the legislature is concerned. There are factions within the party, each of them claiming to be that party. And without any reference to what's happened in the House, they go to the Election Commission and say, we are the group. Election Commission can decide.
1 minute. So.
Now let's see at what point in time does paragraph 15 operate? On the date when he files this application, that is 19th of July. Correct, Mullah? Can't be before that. Even if the election commission were to decide, it could only decide on 19th of July when he moves the election commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's whether he voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority, then how do we move the election commission? And the election commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Mullah, of paragraph 15 operating at all in this case? Therefore, Mullah, to say that paragraph 15 is operative and is independent of all this, Mullah, with the greatest respect, Mullah, is contrary to the very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The election commission of India will decide much later. The question
Yes. Mr. Zibal, what's the next point now? We've got this part of this limb of your arguments here.
Yeah. So, therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Surely, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, he'd not be sitting here. 2, what's the balance of convenience today? That so far the election commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all.
There is no stay of PMC election.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
When they produce the order, there is no stay.
The best of our knowledge,
Hold on. There is no stay today. The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time of 2 weeks.
In the Bombay High Court.
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhvi, SLP.
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Wagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with it. My learned friends are thoroughly confused.
It's totally wrong, my lord. PMC elections, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appearing in that matter, so he doesn't know.
No, I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, my lord. That order we have placed, my lord, in our return submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure.
But the matter tomorrow is about the OBC.
We'll hear you, Mr. Yadnani, we'll hear you. Let's follow some order. Yes. All right.
lot of enthusiasm, moreover. That's all right. Normally, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordships, Manoj, and it will determine, all the issues will be determined.
All right. So prima facie case and balance of convenience.
And then, Manoj, irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What's going to happen? It's irreparable injury. Was to be. Without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Yes, Mr. Sibal, we've made a note of that. Anything else, Mr. Sibal?
Don't take time without repetition. Very brief.
Who are you appearing for, Dr. Singhvi?
Because there are 8 petitions I am appearing for the
All right.
eminent
Yes.
parties, because who are on this side versus that side.
And you will be characteristically brief, Mr. Dr.
I
Singhvi.
am grateful for the word characteristic.
Correct.
Your lordship has always rendered me speechless before I started. May I be very pointed. Your lordships has 4 points in the 10th schedule. The issue is narrow. Whether your lordships on a
Can you just formulate the 4
Yes.
points?
Before I let me do that. Today your lordship is not hearing the matter.
Right.
Today your lordship is deciding the correct balance of convenience to endure till such time after Diwali your lordship hears the matter and renders judgment. That's the only issue today. Now, for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I'll be demonstrating that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Dr.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the election commission and the matter will not go on. There have been 3 dates in between from then to now, including one coming up later this week or next week. So it has been adjourned. That was the lordship understanding. Of course, subject to your lordship adjudication today, no doubt.
Till the application was heard.
Number 3, why this inextricable intertwining and collision was? There are 4 elements of the 10th schedule, which Mr. Simple has shown, but those need to be summarized. One is the phrase original political party.
Just a moment.
This phrase is very important. Political party, oblique original political party. Now, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving lordship original political party, and sometimes they say political party in the same context. If your lordship sees 1C without reading it, it's been read to your lordship, just keep it open with us. Then 2(1)(a), and these are the operative provisions. then explanation, so 1C, 21A, then explanation A. I'm sorry, my apology, was 21B also. 21B also. 21A and 21B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. You have to look at the sub-clauses. Then 2 bracket 2, then 4 bracket I, and many times in clause 4. Now, Willis,
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
yes, yes,
Just as a matter of curiosity, I mean,
yes.
nothing really would turn on this.
Well, it's when they say
It's in 4. It's in 4. 4. 4.
4 in the merger.
Where is original political party merges with another?
The political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea in a minute I'll come to it. It's the same concept. Now, Willis, this is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
Yeah, I'm
briefly
sorry.
argue?
Yes. So
Because
the
just
first
help
is-
us in.
Yes. Number 2, of the 4 elements, the first is political party. The second, split group faction all out permanently from 2003 WEF 1104. Permanently out. That was the big bullets pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet heard, Your Lordship not hearing the matter. If Your Lordship reads the statement of objects, it's very graphic to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3,
Directly?
that is exactly what the election commission is asked to do in the symbols order.
Okay.
I'm just saying, Willis, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November. Let the election commission go on. Because how unreal would that be? Kindly consider. How duplicative, how irreversible. Number 3, and the statement of objects when we come to the final hearing will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, common I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for this? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go, that means it's a new group. That group by itself makes no difference to the 10th schedule. Suppose, let me give an extreme case. Out of 100, 90 go, or 75 go. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. But only merger is the sole defense. Just bear with me on clause 4 for a minute. Just this needs to be read. Clause 4. That was the whole idea of substituting merger for split. It is nobody's case that in whatever form Shiva Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. a member of a house shall not be disqualified under 2(1) where his original political party, the question Justice Chandra should ask, merges with another political party and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you want 75 are gone, 10 are left, 25 are left. And
So the people who remain after a merger,
that's right.
their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger. I stay back and I continue with my own.
I'm very grateful, Manas. I'm very grateful. Because, Manas, and quite right, it is not their fault. The remaining 10 can't be disqualified because 75 have gone with it. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to that.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. Now, Malas, my question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if they proceed, you will disqualify tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? You are deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently held to be disqualified. Well, it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Mr.
Now,
Foxy, you go to the next point.
You just note for one thing. Well, if you are, what happens? Well, there is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena. So you don't merge. Had you merged and knocked at the doors, it would be a new political party, subject to numbers. You want the best of both the worlds. Who are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving a coach and four through this. And Wallace's fifth point is this thing was enacted, Wallace, 15 years, 20 years after on the Ayaram scourge, with a huge amount of discussion and amended in 2003. We are talking of a largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the real who is the real party? Party A, they are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well, it's-
The symbols order, who represents or who is the real party
Yes.
is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only difference is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
Two answers. One answer is that assuming it is so, I'm not conceding that, I'm just answering my lot two alternative points. That has to logically follow, not precede. It's the
See,
first
let me tell you what is really troubling is this.
Yes, yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right. The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election.
Two or three answers. I appreciate that.
Right? That, so that is an area where, there is a little bit of a constitutional thought to be done.
Answer number one. The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by your lordships repeatedly, including the famous case of Saranja. That's answer number one. Your lordship should not be under the impression.
So your contention is that therefore, your contention really is that because the legislative wing of the party
Yes.
is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be prevented, interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of
I were to appear in the Election Commission in symbol order cases. What they issue?
Written in our compiling.
Just to give you
I just give one.
there are 3 or 4 answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages.
The
There are
old one.
old one.
The one.
Common convenience volume. Old one.
ये क्या मेन पेपर बुक में है सर? हाँ.
Two or 3 things here.
What are you showing, Dr. Singh?
Yes. First,
So we don't get, I think it does. What exactly are you showing?
I am showing, Willis, in that volume, common compilation volume, the Election Commission notice at 698, page number.
1 minute.
Yes, sir.
What is the date of that?
Election Commission is dated
Page 1853.
22nd July 2022.
22nd.
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I tried to take a technical objection, but still that. Our training is still incomplete. That 22nd July.
What's the PDF number?
Now, Willis,
1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, great.
Dr. Singhvi, at 12 sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
I'll be very.
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents
So,
after.
Willis, let me be very pointed. Now, this page, which your lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the Election Commission. See the last page, 702. Mother, I'm sorry, I'm not able to see. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, let's just see the top paragraph. Prior to the hearing of the 2 rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That phrase I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be, well, about 10 pages out here. PDF page, no PDF. My learned opponents, well, filing in the EC is very revealing. What they file. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen
You
here.
have said anything very seriously wrong, but this is very interesting what they have said. Kindly see 684.
684.
Yes. It's para 23, small Roman 23.
Yeah.
It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiv Sena. This is directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader is annexed. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so?
that petition can't be filed. So far, there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Well, the filer, the approacher is Mr. Shinde. He's not a member of the Legislative Assembly. Is he not claiming on the basis of the listed assembly status?
Right. Page 687.
Now, 687, on the top fourth line, organizational and legislative wings of the party. Fourth line, para 9, on the top of the page. Then para 10, next para, fourth line, all layers of organization as well as legislative wings. I can multiply this now, my time is short, so please come to Sadiq Ali. The citation is 1972, volume 4 SCC. 1972, volume 4 SCC. 664.
Now, I think that is the
document my lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only
Right.
status is that of a supposed MLA of the Shiv Sena, is what I will say. Now,
you are now reading Sadiq Ali.
Sadiq Ali, para
I think Sadiq Ali is part of the convenience
yes,
compilation.
page 14 of their convenience compilation, the other side, but your lordship will get it in so many forms.
Just give us a moment of.
Para 26 there is. As your lordship knows, this judgment has stood the test of time, even though it is
Election
predating
Commission.
others.
Election Commission.
Yeah, I just saw it.
I'm getting. Well, I am only on the point that there is a huge overlap, direct interconnection. Your lordship decided.
Yes, Dr. Singh,
That's
got
why
it.
I'm not concerned about the final merits.
Very
Your lordship is told that it's two or North Pole, South Pole apart. It's two unrelated issues. That's what I'm objecting. As if they're two unrelated issues. Now, just see what is in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs, I have so many MLAs. Now read this judgment. An election commission says legislative organization. Now read the judgment, para 26.
Para 26.
26, which is at page 677. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. It is in view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the Election Commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength, in our opinion, is very valuable and relevant test. Then, well, they go on. Well, this is, of course, 68 is 15 years prior or 20 years prior to state schedule. Judgment is prior, but I'm at the moment on the judgment's own terms. Well, can you separate? Can you, you are told, that this is unrelated issue. Then, also note para 29, the last 4 lines. majority ballots of houses of parliament and sum total of members of state legislature. Last two lines of para 29 to save time. Last two lines of para 29. In any case. Last two lines of 29.
In any case.
3 lines. Now this third aspect. Symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Because we are one group, we have a fight. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind.
Correct.
Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, Mills, your lordship uses this phrase, it has become a commonplace. There is a lot of weight. Not when the Supreme Court uses it all over, even lower courts. What is the meaning of the subject to outcome? We just say it like that. Your lordship will find the iron case. Your lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singhvi, thanks. Can we wrap up on this?
Yes, I'm done with this. Because I want to only say one thing, that your lordship fellows will keep in mind also this concept of voluntarily gives up. Voluntarily gives up is a very important phrase which your lordship finds in 2.1a, inter alia. How do you voluntarily give up? You voluntarily give up when you don't satisfy the conditions of a schedule. Suppose I expel you. Then, of course, you are not voluntarily giving. That's why I said, in the actual reality of political life, expulsion is welcome sometimes. It is a welcome. But, if you do some activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge, you have voluntarily given up membership. But if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the election commission, Mr. Eknath Shinde, who's the sole applicant. There is no other application. Today, your worships can always decide, but today, he is under a cloud, under the simple text of 2.1a.
All right, Dr. Singhvi, thank you very much. We'll just take a short break and we'll be back and we'll hear these.
Balance of convenience of lordship does not have any impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the of those orders. We can just see those for a moment. That's all that we'll share.
That's a different matter. The option is it exists, is what I'm saying.
This will be
All right.
We direct, there are 3 enough. We direct the parties.
All right.
Corrected. Not to whom? Corrected. Not to whom?
I read under Article 32 by Mr. Prabhu.
Yes. Not.
He was a whip since 2019. So it's
Sorry, Mr. Prabhu,
He
what?
was a whip since 2019.
Manoj, I said we had removed him, I had said.
Mr. Sunil Prabhu.
Yes, we had removed him on 21st of June. I had said so when I was giving my events. We had removed him and you had removed Mr. Shinde, which we said was a wrongful removal as minority evidence. That's what I said.
Right.
Now, my lord, so they find
read
a
under
direct.
32 is by Mr. Prabhu.
That's saying that no floor test should be held.
Yes.
In view of the fact that disqualification of 42 MLAs is pending. Arguments for over 3 hours are held in the matter, and ultimately the court says that, look, in view of the law as laid down, as we cited, the court has said floor test, if at all, should be held at the earliest. And we said, why should you shy away from a floor test? You can't today say because a disqualification is pending, the floor test should not take place, because there are judgments of your lodges to say, even if a disqualification of an MLA is pending, he is allowed to vote in a trust vote, he is allowed to vote on a floor test, he is allowed to vote on the disqualification of a speaker or a deputy speaker. The proceedings and the function of the House cannot be stalled merely because the disqualification is pending. And those are your lordship's judgments on the point, on the issue squarely. And given the fact that floor test is the surest way to determine who actually enjoys the majority in the House, if at all a chief minister is confident enough, he should be more than eager to clear the floor test rather than evade and escape and run away from a floor test. So the court said, and directly said, we do not find any ground to stay convening of the special session. Now, my lords, immediately after that order comes, on the very same day, that evening, when the order is pronounced,
What's the date of that order?
29th of June 2022.
Yes.
On the same day, Mr. Thackeray resigns as the chief minister. Mr. Shinde and Mr. Padnase approach the governor, stake a claim to form the government. Mr. Shinde is sworn in as the chief minister. Then after that, the speaker is appointed. The speaker proves it because they ultimately again challenge the speaker's again appointment and Mr. Shinde's appointment. The speaker is overwhelmingly voted and confidence is reposed. And these are the facts which ultimately led to their all-inclusive one petition which comes to be filed where this IA has. I'm running through some of the other facts which may not be so relevant. So that's the broad background in which they now come up with an all-encompassing writ petition, saying that the decision of the governor to call Mr. Shinde to be sworn in, the floor test, of course, had become infructuous by then because the earlier writ petition, the chief minister had resigned. Then they say the speaker's appointment, etc., all illegal, and the Supreme Court should decide all these issues. Even before the speaker decides these issues, all of these proceedings should be transferred to the Supreme Court and they should be decided. There is no mention in the prayer clause or the writ petition about the election commission. In fact, there are categorical pleadings in the writ petition that the issue of who is the chief Sena is the exclusive domain of the election commission. This is their writ petition, where they say the decision as to who is the chief Sena is the domain of the election commission. Now, after that, my lords, we approached the election commission. The election commission, looking at the nature of representation that we make, say that clearly there are MLAs on this side, there are MLAs on that side, there are representatives on this side, there are representatives on that side. So obviously a dispute has arisen. And issues them notice to come and file a reply, place the relevant documents before the election commission to take a considered decision in the matter.
Mr. Kaul, where did they make this categorical argument that decision should be of?
Yes, yes. Page 8 of our convenience compilation, round D. That petition was filed on 8th of July 2022. But I'll come to the specifics later. So, at that stage, when the Election Commission says, come and file the relevant documents before us, we have to proceed as a coordinate constitutional authority and exercise our jurisdiction to see who represents, because this is really an intra-party dispute. No one is saying, our case is not that we voluntarily given up the membership or we are splitting from the party. These are two rival factions within the party. So the EC said, we'll decide as to who represents the Shiv Sena. They come to the court and say, the EC should not be allowed to go ahead. The EC says, the Supreme Court says, we are giving you more time to go and seek time from the EC to file the documents. That request is again reiterated later, and the court again extends time to file documents before the EC. There is no order ever injuncted, and there was no notice issued in this IE to EC also. The order is go and seek more time to file documents. No injunction order ever passed. And ultimately, my lords, when your lordship passes the order of reference to a constitution bench, on the same day, an order is passed saying that the issue as raised in this IA will be considered by your lordships. So it is factually incorrect to say that on repeated orders of the Supreme Court, an injunction was being granted, or it was an understanding between the parties that the EC will not proceed with the matter.
Just give me the date on which the Election Commission issued the notice.
Yes, ma'am. 2nd of July, 22nd of July, 2022.
And what is the date of the order of the Supreme Court? No injunction, you said, but only time to file a.
Yes, yes. 4th August. It says grants liberty to the petitioner to apply for extension of time before the Election Commission.
Yes.
Now, this is the background. And our respectful submission, of course, first is that this IA is beyond the writ petition itself. No substantive petition has been filed.
One short question. The letter of 1st of July 2022 issued by Shiv Sena Secretary for removal of R4, R10, R27 was made to the Election Commission. You will get it 360.
Yes.
So they wrote a letter to the Election Commission saying that we have removed them from the political party. Am I right?
Yes.
Yes.
And even
That is prior.
even earlier, in June, they had written a letter to the Election Commission informing that they had taken the decision there. And
Not expelled from the party, removed from the post.
Correct, correct.
Just not.
Removed from post.
Position, removed from the position of
Thank-
leader in the party setup.
my lord, so all that I'm saying is, and I'll now summarize what my points in the law is. The law today is laid down by your lordships on a number of these issues as sought to be now canvassed is no longer recent. One is, my lords, your lordships have categorically held that the jurisdiction of the speaker, when examined under the 10th schedule, is to exercise his power to determine disqualification in the House. The Speaker cannot embark upon, those are the words used by the Supreme Court, the Speaker cannot embark upon deciding a split or a merger within a political party. Secondly, what your lordships have held is that
Except with one caveat, Mr. Kaur, that the whole concept of a split now is alien to the 10 schedule. That's one. Therefore, the reason why the speaker can't decide as to whether there was a split is because the 10 schedule now obliterates this concept, effaces the concept of a split. On merger, perhaps you may not be right because merger is expressly a defense under the 10 schedule, under clause 4. Therefore, whether there has been a merger or otherwise may possibly fall within the ambit of this.
I'll show some of the other provisions also will still be in the context of the legislature party, not the
That point you have made. That is
My
not
lord,
the concept.
my lord, your lordships were absolutely right in what your lordships are saying. My submission on merger is only that the speaker's jurisdiction is on the legislature part. That part of subclause 4 of 10 schedule was not read out to your lordships. I'll just read that. Secondly, my lords, your lordships have held that even where the symbols order does not predicate a particular situation or deal with a particular situation, the Election Commission of India, exercising its expansive and the words used are plenitude of plenary powers under Article 324 of the Constitution, is well within its rights to deal with any situation that arises. That is not to say for a minute that I am canvassing that under clause 15 or clause 18 of the symbols order, the Election Commission does not have the adequate power to deal with the situation like that. I'm going a step forward. Even in 15 and 18 were inadequate to deal with the situation that we are dealing with. Your lordships have said the plenary powers are enough for the Election Commission to deal with any such situation. But here, categorically, 15 deals with two rival factions within the party. And 18 covers situations which the Supreme Court has interpreted as interim directions or other orders which may be passed in the interest of justice. And your lordships in Sadiq Ali, while in detail dealing with the symbols order, categorically first dealt with the issue that a situation arises of two rival factions within a party. 15 is squarely the provision which sufficiently empowers the Election Commission of India to deal with it. And then Sadiq Ali proceeded to say that while considering it, both the legislative majority and the political majority will be looked at. But that is the Election Commission of India. A constitution bench of this court has already said that while the speaker decides the 10th issue, 10th schedule, jurisdiction of disqualification, he can't get into the political party because the very nature of the dispute is such, as my lords pointed out today at the start of the hearing, 1.5 lakh, 50 lakh representation by us. Zilla promotes, talukas, district officers. Evidence is led. The powers, as your lordship knows, have been vested on the power, and the Supreme Court has said powers of the state, powers of the court on the Election Commission of India. That is the alternative adjudicatory machinery created to deal with each of these issues.
Only thing, Mr. Paul, the genesis of the entire dispute, I think that's really the sense of the submission, that the genesis of the entire disputes arises from what happens on the floor of the House. Right? Absent what happens on the floor of the House, everything else wouldn't have taken place. That's their contention. Now, if that is so, then the issue as to what happens, the symbols order predates the 10th schedule. Sadiq Ali predates the 10th schedule. Right? Because Sadiq Ali is in fact Justice Hegde Grover and Justice Khanna.
That's
Now, Sadiq Ali predates the 10th schedule. Therefore, when Sadiq Ali speaks of the powers of the EC to determine both the legislative and the organizational majority, that the former part, namely its authority to decide the legislative majority, was at a time when the 10th schedule was not in operation. Now, does the fact that the determination of whether or not a disqualification has taken place is now exclusively entrusted to the Speaker, does that to that extent dilute the authority of the EC? And if so, then what is the impact of that decision which is entrusted to the Speaker? That is, I think, what they were really driving at.
So, Manoj, firstly, post Sadiq Ali also, and I'll show those judgments if required. There have been judgments.
No, we've seen those judgments which just formulate the point.
Post Sadiq Ali also, which have talked about the interplay of 10th schedule, symbols order. There is nothing to suggest. There is nothing to suggest that any way does the 10th schedule dilute the exercise of jurisdiction under the symbols order 1. We, my lords, the constitution bench of this court categorically says that when you embark upon this inquiry, it is restricted to majority in the House. Because the very nature of inquiry that we are talking about, where a political party is completely beyond the machinery provided for the Speaker or the powers vested in the Speaker. And that is why that whole line of judgments, my lord, where your lordship said powers of the state, powers of the court, all vested in the Election Commission of India. Detailed evidence. Now, will the Speaker get into interacting with every taluka pramukh, every district officer, every president of every area, the registered membership of the party? It doesn't get into all that. There is no machinery for it. That's not the intent. And if your lordship sees everywhere in the 10th schedule, political party in a context and then followed by legislature party, as your lordship pointed out, including clause 4 of 10th schedule. And it is interpreting that a constitution bench of this court says that when you embark upon the journey of deciding on disqualification from a house, don't mistake this for a power to decide the larger political issue or division in the political party, which is there. And I tell your lordship, inherently it can't be done by the Speaker. And there is nothing today in this matter, my lords, nothing at all as far as the pending petitions are concerned, whose outcome in any way will impact what is pending before the Election Commission of India and take their case at the highest. That we will all be disqualified as members of the House. I take their case, that's the maximum that can happen, my lords, that we are disqualified as members of the House. Does that stop us? Does that stop us from going to the Election Commission as a member of a political party to claim that we represent or we are the Shiv Sena?
But suppose you were to argue on a demurrer, assume for a moment that the person who has moved the EC is disqualified. All right, for a moment on a demurrer. Does that disqualification of the person who has moved the EC impact upon either his locus or the authority of the EC to determine who really represents, which of the two factions represents the party?
So Mara, that's a very pertinent question. Let me So, my lords, the question that my lords put to me, let me give your lordships two stages which can answer. One is what happens, what is happening here, and the other is what your lordships put. One is that disqualification petitions are pending. The Supreme Court has told the Speaker on their request not to, in the meantime, take any decision on those because the Supreme Court was seized of the matter as far as the Speaker's exercise of jurisdiction is concerned. And pending those petitions for disqualification, can an MLA or an MP be prohibited from approaching the election commission? Your lordships in any number of judgments have said that even when disqualification petitions are pending, an MLA and an MP is well within his rights to participate on the proceedings of the House. Vote, exercise all that is vested in him under the Constitution.
So until he is disqualified, the consequences don't attach at all.
Absolutely,
That's the rationale for it.
One, and including my lords,
Yes.
including the line of reasoning that your lordships took
Yes.
in Nabam Revia, that
Yes.
that if a deputy speaker or a speaker of membership, that he can always proceed in a direction where his own disqualification, that was another link, would be accordingly impacted. So till I am disqualified, I continue to be a member to participate all its vigor and robustness in the proceedings of the House.
At page 359, that very question. This is a letter written by Uddhav Thackeray to Eknath Shinde saying that you have been indulging in anti-party activities and have also voluntarily given up your membership in Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So this doesn't affect his primary membership. As if his primary membership is actually affected, then he can't maintain a petition before the election commission. That's perhaps their argument.
Yes.
So therefore, at the threshold, election commission cannot maintain a petition on his behalf. But it is, if it is not affecting the primary membership, and it's only a post he continues to be a member of the political party, then he can perhaps file.
And my lord, just to add to what your lordships are saying, this is their contention that I have given up. My whole case is who says I have given up the membership voluntarily. Otherwise,
that is yet to be considered.
That absolutely that is yet to be considered. My whole case is that a set of 14 MLAs decide that I am removing something and overwhelming majority is on one side. You take a unilateral decision with a hopeless minority and then say, I've disqualified you or you voluntarily given up a membership. We have repeatedly said that we are the Shiv Sena, whether it's in the Lok Sabha or it's at the Legislative Assembly. We represent an overwhelming majority within the party. We've never said we've left the party or we need to merge with someone under 4 to be protected. We have right through said that whatever actions a set of people who are in a hopeless minority took have no sanctity of law, are unsupported by any legal provision at all, and you could not have done, you did it without authority. So with such emphaticness, when it is said that you voluntarily gave up the membership of the party, who will decide it? Because you say I've given up voluntarily the member under 10 schedule, or will the speaker decide it under the 10 schedule? Because your lordships have held that the power of the speaker and the decision of the speaker under clause 6 of the 10th schedule is final on these matters. And that decision is still pending. My lords, was the question that your lordships put to me, that suppose a person, now this is the first case where no decision has been taken, the issue is pending. The other is I am actually disqualified and I incur the wrath of Schedule 10 of the Constitution by whatever action there's a decision of the speaker against. That still does not, as my lord said, deny me the primary membership of the political party. I'm still entitled to approach the election commission for whatever grievances I may.
That you have said, so that you are not removed as a member of
Yes.
the political party. You may be removed, correct, disqualified as a member of the legislative party.
And now, my lords, they sought to rely on Sadiq Ali to say that, look, both the words legislative and organizational majority have been referred to in Sadiq Ali. Now, organizational and legislative majority is referred to in Sadiq Ali from the perspective of the EC deciding, not from the perspective of the speaker embarking on an inquiry as to who represents a majority in the political party. Then they relied, my lords, on to say that this will have a bearing on the matter because a judgment of this court said, and I'll read out in what context the judgment was when I come to the case law, to say that any disqualification ex post facto relates back to the date when you were disqualified. And thus, if they were disqualified on that date, that's the end of the matter. Quite apart from the fact that even if I was disqualified, it doesn't stop me from going to the EC. But the reason the Supreme Court said ex post facto, and there are other paras that I need to show, was this. That was a case of a BSP government in Uttar Pradesh. A decision was taken to dissolve the assembly. The cabinet decision was yet to be communicated. I'm just very briefly giving. 13 MLAs of the BSP went to the Samajwadi Party and said, stake a claim to form the government. Because these 13 MLAs went to the Samajwadi side to stake a government, Mr. Maurya at that stage made a petition to the speaker saying that this is an overt act on part of 13 MLAs to show that they have voluntarily given up the membership of the party and thus they ought to be disqualified. So the speaker was seized of this issue of disqualification of MLAs as on that date because 13 MLAs had gone to the Samajwadi Party side. In the meantime, another 24 MLAs joined the 13 MLAs and they claimed that there has been a split in the party. Now the speaker went ahead and decided the issue of a legitimate slip with 24 joining 13 and did not decide the issue of disqualification, which Mr. Maurya prior in time had directed, saying that your very act of going and seeking support from the Samajwadi Party amounts to giving up an anti-party activity, voluntarily giving up membership. In that context, the Supreme Court said, as far as exercise of powers by the speaker is concerned, that this disqualification will relate back to the date when the speaker was required to exercise the jurisdiction and the speaker could not have decided on the split within a party without deciding their original disqualification from the House, which stood there. It is in that context that the word ex post facto was used. And I'll show those two specific paras. The same judgment, my lords, the Supreme Court then goes on to say that you as the speaker can't embark upon and decide within a political party what happens. Your lens is only the lens of a legislature party that you have to see it. And inherently, my lord, the proposition which is sought to be forwarded will be impossible to implement. A, the constitution doesn't say so. B, practically and inherently, it's impossible if you expect the speaker to get into these issues of lakhs and lakhs of memberships across the country without the necessary adjudicatory machinery.
So according to you, both the powers are different. Jurisdiction under both the powers are different. And the inquiry under both are different.
Completely different. If at all, my lords, if at all, a finding of the EC may help speaker, if at all, but nothing that the speaker decides will ever impact a member approaching the election commission. So to say that the two petitions are intertwined, thus this must await the decision in the main matter, is completely wrong. Now, my lords, even as far as that one question which is referred to, which is the last question, J, which I just...
Scope of powers of the EC.
My lords, all that is, I'm very clear. What is the scope of powers of the Election Commission of India with respect to determination of a split within a party? No one has questioned the vires of the symbols order has already been upheld by your lordships. No one has ever questioned the power of the Election Commission. All that has been said herein is the scope of the powers of the Election Commission. Now, if I were to accept the argument as sought to be forwarded by the petitioners, my lords, then till the Constitution Bench of this court decides on the scope of powers of the Election Commission. This may be the Shinde versus Thakre matter, but there could be another matter where there are disqualifications of MLAs and another set of people go to the Election Commission. So the Election Commission is denuded of its powers as a coordinate constitutional authority to continue and do what it is mandated under the Constitution to do, because your lordships are seized of the question of the scope of the Election Commission. This is one matter, my lords. All that has been said, court in its wisdom thought that the scope of the powers needs to be looked into. My respectful submission would be, my lords, even the scope of the powers, the horse the symbols order, in the light of judgment of your lordships, is expansive and plenary. But the symbols order itself under clause 15 and 18 specifically provides for a situation like ours, which is rival factions within a party, interim directions to be given. And my lords, your lordships in any number of judgments again have held that pendency of disputes does not bar the Election Commission from issuing any interim direction which it feels is necessary in the interest of justice in the meantime. Now, another argument raised was, what happens if the Election Commission suddenly freezes the symbol? Who will be able to contest? There will be mayhem, there will be chaos. What will happen? Now, my lords, your lordships have also held that you are entitled, if you represent the overwhelming majority, whatever you think you represent the overwhelming majority within the party, to go and say that we are entitled to represent the party and use the symbol. That's your legal right. Symbol is otherwise not the property of an MLA. It's the decision of the Election Commission. But I have a legal right to claim that I can use it. That's one that I can do in this matter. Presuming, suppose a situation were to arise in the court and the Election Commission was to come to a conclusion, no, we can't decide. There are orders, where freezing orders have been passed by Election Commission, and in the intervening period, temporary symbols have been given. Those are not jurisdictions of Election Commission to decide. You today, in a 32, want the court to be seized of the matter, exercise the jurisdiction of the Speaker as a court of first instance, exercise the powers of an Election Commission under a 32, and none of these constitutional bodies should be.
Yes, Mr.
My lords, I have two judgments to show to my lords.
Which are those judgments?
One is, my lords, the Rana judgment. Other is Sadiq Ali. And third is Palanis.
Right. So we give you about 5 minutes after lunch.
Yes. My lords, just.
Yes. On the days, my Lord the Chief Justice indicated, on the days when the Constitution Bench sits, the Constitution Bench runs for the whole day. So we continue.
We'll continue.
Yes. My lords, I just require 15 minutes from your lord, because I need to show 3 judgments and some provisions to it.
Indulgence, a brief supplement by me and Mr. Singh. 10 minutes each.
Right after Mr.
Paul finishes.
After Mr. Paul finishes,
Just a
maybe
brief.
5 or 10 minutes,
10 minutes
between the two of you, and then we want to hear Mr. Data,
Yes,
because
yes.
he's preparing for a constitution body.
Most important. Question number F.
Yes.
Or the deferred questions. Question number F is, what is the scope of the election commission?
That's
J.
J. We'd like to hear Mr. Data. We do, of course, since we are appearing for party, we've heard on this side as well. But we want to hear Mr. Data.
Yes, my lords, I'll finish with it. Very
both the constitution benches are running late because Justice Paul and I, we were in a meeting for technology purchases for the Supreme Court and other things with Justice Nazir. That's why we were both the reason for the delay actually.
Be kind enough to have the compilation of case law that we had submitted.
Yes.
Volume 2 of the case law compilation that we had. Correspondent number 4.
Sir, we can't hear you.
Your voice is
Can't hear you.
post lunch should be there should be a greater.
That's lack of enough food.
Also with the live streaming, unless your voice goes into the mic,
Hi.
there might be a problem for the audio
The
quality.
audio.
Manoj has this volume 2, which is compilation
Constantly.
by respondent number 4.
Yes. Title is compilation of it.
Comparison of judgments. You want to read Sadiq Ali?
So, Manoj, this is the constitution bench in Rajendra Singh Ram.
Yes, last one.
Starts at 191
Yes, we've got.
at page 230, 213.
Whoever has done the bookmarking has done it very well.
Very
Must thank the young juniors who have done this exercise.
Some absolutely outstanding youngsters assisting us in this matter.
Otherwise, what happens to us? I know the travails of, because when you people conclude arguments in the final hearings and we have to start dictating, then you have to start scrolling down, which is a big headache. I mean, when it's bookmarked, it takes you a second to go to that particular.
Right. Your Lordship, be kind enough to have page 213.
213. Rana has how many judges?
5.
Something seriously wrong.
Mr. Cole, you had mentioned Sadikali is that you'd like to refer to Rana and
Change
the third one.
Manani Swami.
आपको platform है ना?
Kindly have placitum B on 213, which starts with, it is therefore not possible. That's para 5. The para 25 starts at page 212.
Yes, we got it.
It is therefore not possible to accede to the argument that under the 10th schedule of the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party, as contemplated by paras 3 and 4 of the 10th
Sorry, I didn't get this.
I'm also.
Are you reading
Para 25,
Para 25 starts at page 212.
but it starts as in the context of the introduction.
Yes, that's right.
And you're
It's like
I'm on page 213, placitum B.
it is therefore not possible.
It is therefore.
Yes.
I don't have that.
yes.
It is therefore not possible to accede to the argument that under the 10th schedule of the Constitution, the Speaker has an independent power to decide that there has been a split or merger of a political party as contemplated by para 3 and 4 of the 10th schedule of the Constitution. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of the business of the House, but that is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim being determined by him that a member or a number of members had incurred disqualification by defection. To that extent, the decision of the Speaker in the case on hand cannot be considered to be in order in terms of 10th schedule of the Constitution. The Speaker has failed to decide the question he was called upon to decide by postponing a decision thereon. There is therefore some merit in the contention of the Learned Counsel for BSP that the order of the Speaker may not enjoy the full immunity in terms of 6.1 of the 10th schedule of the Constitution, and that even if it did, the power of judicial review recognized by the court in Tehoto Holohon is sufficient to warrant interference with the order in question. In a sense, this aspect may not be of great importance in this case, since going by the stand adopted on behalf of 37 MLAs, the Speaker was justified in keeping the petition seeking disqualification of 13 MLAs pending, even while he proceeded to accept a case of split in BSP. The question really is whether the Speaker was justified in doing so. As we have indicated above, the whole proceeding under the 10th schedule to the Constitution is initiated or gets initiated as part of disqualification of a member of the House. The disqualification is by way of defection. The rules prescribed by various legislatures, including the UP legislature, contemplate the making of an application to the Speaker when there is a complaint that some member or members have voluntarily given up his membership or their membership in the party. It is only then that in terms of 10th schedule, the Speaker is called upon to decide the question of disqualification raised before him in the context of para 6 of the 10th schedule. Independent of a claim that someone has to be disqualified, the scheme of the 10th schedule or the rule made under do not contemplate the Speaker embarking upon an independent inquiry as to whether there has been a split in a political party or there has been a move.
Yes.
So, my lord, the Constitution bench of this court squarely says on this point that look at it from the lens of a legislature party, the split, the merger, but political party, what happened? While deciding disqualification under the 10th schedule, don't embark on an inquiry as far as the political party is concerned, which is not your domain or jurisdiction. And it was in this context, my lord, as I respectfully submitted, and on which great emphasis is laid by the other side, that it said that disqualification is ex post facto. Because on the date the Speaker ought to have decided the disqualification, because 13 MLAs had gone with the Samajwadi Party to support another government. Instead of doing that, the Speaker went on to decide on a subsequent event where 24 MLAs had joined the 13 MLAs and said there's a split in the party and supported that decision. Now, if those people had been disqualified earlier on a date, that split would not have occurred. Now, with great respect, how can that ex post facto used in that context be meant to say that if ultimately you're disqualified from that day, you cannot approach the election commission? I put their case at the highest, even if I'm disqualified with an ex post facto application. My right to go to EC as a primary member of the party is still not taken away.
Yes.
And secondly, in the present matter, as on date, and all the issues are pending, whether I have voluntarily given up my membership, whether I have defied the whip of the party. Now, which whip will be considered? I'll show the Maharashtra Assembly rules. The Maharashtra Assembly rules provide for a leader of the legislature party and a member is the member of the legislative assembly. It is the leader of the political party who writes to the Speaker and points out who is the leader, what are the designations of various MLAs, etc. Here, you claim someone to be the whip, we claim someone else to be the whip in the matter. Your whole case is that I have defied the whip, whereas our case is I have not defied the whip. The person that you appointed was appointed by a handful of MLAs. Whereas as we are concerned today, the majority has removed it who was appointed earlier. That is our case. Now, these are all issues, right or wrong, pending before the Speaker, and the Speaker will take a call. And in terms of clause 6 of the 10th schedule, his decision in this respect will be final.
All right.
So,
Anything else?
yes, so madam, 2 more judgments. Would you?
What are you citing them on?
Now,
Which is the next one?
The second one that I am citing to your lordships is Palana Swami.
What page?
Page 139 of the same compilation. At page 154.
This is the third last judgment.
Para, sorry.
Yes, paragraph 25 and 26. Hello, sir, paragraph 25 on page 154.
Yes.
Yes.
The Election Commission in the past has exercised plenary powers under para 18 for issuing interim directions regarding allocation of common symbols to two factions when the dispute under symbols order was still pending before it. It was argued that the Election Commission cannot do so once it had finally decided the dispute. There is no difficulty in agreeing with the proposition that once the dispute has been finally decided by ECI, the question of invoking powers of para 18 by ECI would not arise. However, if the dispute is pending inquiry before ECI or the final decision of ECI is sub judice in the proceeding before the Constitutional Court, providing for an equitable arrangement in the interest of free and fair elections and provide equal level playing field to all concerned would be a just and fair arrangement. Assuming that the provisions of the symbols order do not predicate the nature of directions that may have to be issued by ECI, nothing prevents ECI to exercise its expansive and plenitude of plenary powers under Article 324 of the Constitution of India to deal with a situation such as the present one for ensuring conduct of free and fair elections. The purpose I am citing it, my lords, is that apart from clause 15 and 18, which adequately deal with the situation at hand, presuming the symbols order did not contain a provision, the Supreme Court says that even if a provision of the symbols order does not predicate or deals with a particular situation, the expansive powers, the field of powers given, can deal with situation under Article 324 of the Constitution.
Right.
Now, my lords, the third judgment for your lordship's kind consideration is Sadiq Ali. Please have Sadiq Ali. Page 1, my lords. At page 11. Para 20 on page 11.
1 minute.
Yes.
Which para?
Para 20. That's 4 paras I need to read. Para 20. Starts with a perusal of different paragraphs.
Yes.
Yes.
May I, with your lordship's permission? Perusal of the different paragraphs of the symbols order makes it manifest that they provide, as is made clear by its preamble, for specification, reservation, choice, and allotment of symbols at elections in parliamentary and assembly constituencies, as well as for the recognition of political parties in relation thereto, and for matters connected therewith. One such matter is the decision of a dispute when two rival sections of groups of a recognized political party claim to be that party for the purpose of the symbols order. Para 15 provides for the machinery as well as the manner of resolving such a dispute. Now kindly have para 22 on the next page. My lords, that para 22?
Yes.
On the next page. Let us now go back to paragraph 15. The occasion for making an order under this paragraph arises when the Commission is satisfied on the information in its possession that there are rival sections of groups of a recognized political party, each of whom claims to be that party. The Commission in such an event decides the matter after taking into account all available facts and circumstances of the case and hearing such representatives of the sections or groups and other persons as desired to be heard. And now kindly have the next paragraph, that is paragraph 23. Somewhere in the middle, my lord, which starts with the Commission in circumstances had to decide the matter.
Yes.
The Commission in the circumstances had to decide the matter under paragraph 15, and we find nothing objectionable in communication dated so and so sent to two rival parties on its behalf, wherein it was stated that the dispute appears to have arisen in which two of the groups in the recognized political party known as Indian National Congress for the purpose of symbols order. Then kindly have para 25 and 26. These are important. Para 25, page 14.
Yes.
Para 25, my lord, somewhere in the middle says for determining as to who are members of AICC. For determining as to who are members of AICC and delegates, the Commission accepted those persons as members of AICC and delegates who held that position in the earlier session of the Congress at Faridabad before the split. In view of the removal and expulsion which followed in the wake of the split in the Congress, the Commission, in our opinion, adopted proper approach for determining as to who should be taken to be members of the AICC or delegates, more so when in the opinion of the commission, the validity of those removals and expulsions was open to question. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AIC members and delegates who supported Congress J, have not been shown to us to be incorrect. In view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported Congress J. As Congress J is a democratic organization, the test of majority and numerical strength, in our opinion, was very valuable and relevant test. Whatever might be the position in another system of governments or organization, numbers have a relevance and importance in a democratic setup of government or political setup, and it's neither possible nor permissible to lose sight of them. Indeed, in view of the majority, which in the final analysis proves decisive in a democratic setup. And now kindly have, my lords, paragraph 35 on page 17. Paragraph 35, my lords, and the latter half starts on the right side with the commission in resolving this dispute.
Yes.
The commission in resolving this dispute does not decide as to which group represents the party, but which group is that party. If it were a question of representation, even a small group, according to the constitution of the organization, may be entitled to represent the party. Where, however, the question arises as to which of the rival groups is the party, the question assumes great competition, and the numerical strength of each group becomes important and relevant factor. It cannot be gainsaid that in deciding which group is the party, commission has to decide as to which group substantially constitutes the party. And now kindly have paragraph 40, which starts at page 18. Kindly turn to page 19, my lords, because I'm skipping through the other parts since there's time. Please have paragraph 40 on page 18, but kindly come to paragraph 40, which continues on page 19. And about somewhere in the middle on the right-hand side, it starts with, if on the other hand, a dispute arises between two rival groups. And my lords have got that. If, on the other hand, a dispute arises between two rival groups or allotment of a symbol of a political party on the ground that each group professes to be that party, the machinery and the manner of resolving such a dispute is given in paragraph 15. Paragraph 15 is intended to effectuate and subserve the main purpose and objects of symbols order. The paragraph is designed to ensure that because of a dispute having arisen in a political party between two or more groups, the entire scheme of the symbols order relating to the allotment of symbols reserved for the political party is not set at naught. The fact that the power for the settlement of such a dispute has been vested in the commission would not constitute a valid ground for assailing the wiles of in striking down paragraph 15. The commission is an authority created by the Constitution and according to Article 324, the superintendence, direction, and control of electoral rolls for and conduct of elections to parliament.
Yes, Mr.
Yes. So, my lords, my respectful submission is that Sadiq Ali in detail deals and says any dispute within the party, the entire machinery and jurisdiction is vested in the Election Commission of India. And one more argument flows from paragraph 25 and 26 is this, my lords, that they say that while determining majority, the date before when the dispute arose will be taken as the date, because after that there is a conflict. Now here, barely for you to get up and say, you're disqualified, then they stand disqualified, they've given up voluntarily, the membership is of no consequence. Right. Now, my lords, just two more judgments and I'm done. Which will not, I'll just get the citations. I will not trouble your lordships with those judgments. The one is All Party Hill Leaders Conference versus W.A. Sangma, 1977, Volume 4, Volume 4, SCC 161.
That's part of your compilation.
I'm very grateful. Paragraph 37, 41, and 42. And my lord, what they specifically say is that a fraction of the judicial power of the state has been vested in the Election Commission of India. A complete machinery has been provided, and the Election Commission of India has the exclusive jurisdiction to decide all that it has been provided for, taking it away from the courts. That is the purpose. And lastly, my lords, is Kanhaiya Lal Kumar versus R.K. Trivedi, 1985, Volume 4, SCC 6 to 8, paragraphs 10 and 13, effectively, my lords, on the point that even after the deletion of clause 3, sorry, even after the introduction of the 10th schedule, my lords, discussion on Sadiq Ali, the other provisions of the 10th schedule, the symbols order was all discussed. And nowhere has ever the Supreme Court ever said or taken a view that with the coming in of the 10th schedule, the symbols order gets diluted in any manner whatsoever, or the jurisdiction of the symbols order gets diluted with the introduction of the 10th schedule. That's a judgment I'm giving for your lordship's kind consideration. Now, lastly, my lords, kindly just have the provisions, just the provisions for a minute of the Constitution. Three provisions I just would request your lordships to see. First, clause 2 of the 10th schedule. My lords have that. Subject to the provisions of 3, paragraph 4 and 5, a member of the House belonging to any political party shall be disqualified from being a member of the House if he has voluntarily gives up his membership of such political party, or if he votes or abstains from voting in such House contrary to any direction issued by the political party to which he belongs, or by any reason or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, in such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. Now, kindly have, my lords, has the deleted portion of clause 3 which used to exist. My lords, has that as part of the page 15 of our compilation. Page 115 of our compilation.
Yes.
Volume 1. Where also,
Yes.
only reason I am citing it is, my lords, that and 4 both are political party, and 1/3 of the members of the legislature party was used in 3. And similarly, as my lords pointed out in 4, the latter part of 4(2) has 2/3 of the members of the legislature party. So to pick up political party in isolation in 3 and say that look, it says political party, and that has to be decided, no. A constitution when says that has to be seen from the lens of a legislature party. That is to be done in this matter. Now, my lord, lastly, the Maharashtra Assembly rules, just have them for a minute, because just for the completion of page 90 of our compilation, page 99, volume 1.
In the same.
To F, leader in relation to a legislature party, the party whose by it, party chosen by it as its leader, and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge the function of the leader of the party for the purposes of these rules. Then kindly have 2G. Member means a member of the Maharashtra legislative. Then rule 3(1) on the next page, 3(1) and 3(4), page 100. The leader of each legislature party, other than the legislature party consisting of only one member, shall within so and so, and kindly have A, statement in writing containing names of members of some legislature party together with other particulars regarding such members as in the form 1, and names of designations of members of such party who have been authorized by it for communicating with speaker for purposes of the rules. And then rule 3 subclause 4, when on page 102. Whenever any change takes place in the information furnished by the leader of the legislature party under sub-rule 1 or by a member under sub-rule 2, he shall, as soon as may be thereafter, and in any case within 30 days from the date on which such a change has taken place or within such period as the speaker may, for sufficient cause allowed, furnish in writing information to the speaker with respect to such change. So the speaker always interacts with leader. Leader is the member of the house and he gives all details of who's the whip, who's not the whip. Now, if there's a change of whip, the speaker will ask the leader. He's not going to go to the political party and conduct a vote who's the whip there or not. That is the purpose of this. And all parties understood it to be the same way, because whether we issued our official communications or they issued their official communication, they're all on the letterhead of the legislature party to say that the whip has been appointed. So to say, I'm very grateful, my lord, your lordship is very kind and thank you.
Yes, Mr. Congress.
Implemented very briefly. The two relevant aspects of lordship may kindly notice. And my lord, since the time is short, I'm not going contention by contention and my lord, prima facie case balance of convenience. We just supplement what my learned friend has largely asked. Two relevant aspects, my lord, that the Shiv Sena had a pre-poll alliance with the political party of pre-poll alliance. I'm only leaving it at that, not making any submission as of today. There is a resignation by the then Chief Minister on the floor of before the test on 29th of June 2020. And that, my lord, in our respective submission from our side, was a conclusive evidence of losing the confidence of the House in it, and he chose to resign. Extremely relevant facts for even for prima facie case to be kept in mind, a pre-poll alliance and resignation by the then Honorable Chief Minister before the floor test is taken. Third, the no confidence in the Deputy Speaker, which came into existence in writing, expression whereof it came into existence in writing on 21st of June 2022, is achieved, the test thereof is achieved on the touchstone of Article 179C, because my lord, a speaker can only exercise his function and jurisdiction if there is no lack of confidence in that office. If there is a lack of confidence in that office, he cannot proceed further, because that is the requirement of 179C of continuous existence of confidence in that office. And my lord, the floor test achieves both the purposes. The confidence in the leader of the House as the Chief Minister and the government, and the confidence in the office of the Speaker also simultaneously. So two orders were passed by your lordship, my lord. The first order on 27th of June 2022, giving time of 2 weeks to file reply to the show cause notice issued by the Deputy Speaker, was nothing but compliance with the principles of natural justice, because 2-day notice was given when the requirement under the rules is at least 7 days notice. Lordship may just make a note. I'm only on the broader submission and prima facie case. What is the nature and scope of the order which your lordship passed? So, my lord, on 21st of June, there is lack of confidence in the Deputy Speaker. Deputy Speaker has issued a show cause notice giving 2 days when the rules require minimum of 7 days. A writ petition is filed, and in the writ petition, your lordship passed an order on 27th of July by just seeking compliance with the principles of natural justice, not restricting any authority not to discharge. That's, my lord, utmost respect, my lord. A confusion is sought to be created, as in the order of 27th of July, some kind of a curtailment of jurisdiction of any authority. Kindly have a look. I'm not reading, my lord. Kindly have a look at the second last paragraph of the 27th of June order, 27th of June order, which only makes available period of 2 weeks time to respond to the show cause notice given by the Deputy Speaker. Number 4, my lord, the non-existent assumption on the part of the other side, no matter what reply you could have given, you are to be treated as disqualified on the issuance of notice itself. The lack of confidence in the office of the Deputy Speaker further gets strengthened by such kind of a contention that no matter what your reply could have been, you were deemed to be disqualified the day when they are representing your lordship should be treated as disqualified. Now, my lord, kindly come to the document in volume 1 at page 82, my lord, which are the 1968 symbol order, only 2 submissions on that. My lord, the political party is not defined in the 10th schedule. Political party defined in the 1968 order, your lordship have seen. But before that, my lord, differences and dissent, which your lordships have observed on so many times in the part of democracy in every sphere. Differences and dissent is also an essential part of intra-party democracy. The recognition, acknowledgement, and incorporation of that intra-party democracy, my lord, and differences and dissent is, my lord, in clause 15 of the order. Kindly have a look before I go to that. Page 82, my lord, of this document, which is the symbol order. Volume 1, my lord, of the documents on the file by R4. The third paragraph, whereas it is necessary and expedient to provide. And last line, my lord, recognition of political parties in relation thereto and matters connected therewith. So free, a very important, significant aspect of that is recognize political parties and the matters in connection therewith. Now kindly come to the next page. Subclause H, political party. And political party defined here because of the plenary jurisdiction to be conferred upon the Election Commission of India on the recognition and incorporation of the principle of intra-party democracy, clause 15. Now, political party means an association or body of individual citizens of India registered with the Commission as a political party under Section 29 of the Representation of People Act. Now, my lord, various powers have been conferred upon the Election Commission starting from clause 14. Kindly have a look at that, my lord, page 91.
And was 14.
Page 91, clause 14. Please see, my lord, the width and the plenary jurisdiction of the Election Commission, and it is all under 324 for conduct of free and fair election, where dissent differences even within the political party in the hallmark. Kindly have a look at that, clause 14. Power of Commission to issue instructions to unrecognized political parties. So that also is the concern of the constitution makers and then culminating into 1968 order, an important feature. Even a non-recognized, unregistered political party. 15, my lord, I would like to read, but before that, kindly have 16. So when, my lord, the split and merger, my lord, there are two different clauses in clause 7, we deal with split and merger is 4. That split and merger was originally a part of 15. And my lord also dealt with in clause 16. Kindly have a look at clause 16. Power of commission in case of amalgamation of two or more political parties. And then 16A, power of commission to suspend or withdraw recognition of a recognized political party. So, my lord, absolutely plenary jurisdiction. Now, kindly permit me to read 15 once again, my lord, at the cost of repetition. Power of commission in relation to splinter groups or rival sections of a recognized political party. When the commission is satisfied, and kindly see, my lord, it can be its own motor knowledge of the commission itself. It can come on an application because the word used are on information in its possession. It can come from any source. It is only signify the importance of this aspect for the free and fair conduct of election. In possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. I pause here for a moment. As my other friend pointed out, my lord, in clause 3 we stand withdrawn from the 10th schedule. On clause 4 we still continues to remain there. The concern is only with regard to number in the legislative party. It has nothing to do with the political party. Clause 2(1)(a) and 2(1)(b) that you are defining the directions of a political party, or you have voluntarily given up the political party, can apply, my lord, without the involvement of Election Commission if there is no cloud on who the political party is. The moment the question arises, who is the leader or who is the political party, as the surgically says, you travel to 15 of the 68 order, total exclusive jurisdiction of the Election Commission of India. So kindly see 15, my lord, which I just complete and then go straight to the 10th schedule. The commission may, after taking into account all the available facts and the circumstances of the case and hearing such representatives of the sections or groups and other persons that desire to be heard, kindly mark the next word, my lord. Decide. So for the purposes of 21A, political party, there is a question mark, the decision has to come from here, not from the office holder. Decide.
The issue is not so much whether the election commission has the power or not. What they argue is the batting order, which should be decided first. But the question is, would that arise in a context where the channels are completely different and the process and the method and authorities are all different? But are there any cases where the issue relating to anti-defection as well as matters relating to party determination have been commonly taken up, not episodically, but at the same time?
My lord, I'll just check up, I'll confirm it, but I'll come back to your lordship.
Flagging this.
My lord, please permit, I have understood, my lord, I'll see. My lord, I'm coming to your lordships are putting it. I'm sorry.
Yes.
Lord, your lordships are putting it to me that in which order these two issues to be decided, because let us assume that the two issues does arise, that who is the leader of the party and whether that incident of disqualification has taken place or not. If these two issues are to be decided, it must be decided first. That's what your lordships are wanting to know. My lord, my respectful submission is this. I will need go to straight away to 1A and to 1B of the 10th schedule in a moment. My lord, what I was reading here is the decision who is the political party, who is the leadership, who has to give direction on behalf of the party in the name of the party. That decision can only come from 15. Now I'm not only see the 10 sheet, but before that, kindly come to page 8 and page 10 of this compilation 1. Because if this is the position, my lord, taken on oath before this honorable court, where the writ petitions are filed on daily basis on every event taking place, after this position is taken up by the other side before this honorable court, ground D, my lord, I want to read only 4 lines and ground next page, page 10. Para 36. Then, my lord, therefore, a contradictory position by filing a writ petition would not have been agitated, and that is the reason why no writ petition, quasi-election commission jurisdiction or election commission proceeding is not filed.
Ground D where?
Ground D at page 8.
And this is
My
ground
lord, that pages are at the bottom. On the top, there is some page 38, but the running page of this compilation is page 8 and page 10.
This ground D, Mr. Maninder saying, this ground
in the writ
is
petition.
part of the writ petition.
Writ petition filed by them.
There are.
No, my lord, your lordship must know, my lord, that on every event taking place after the floor test, they were filing writ petition. They have taken this position in this writ petition where there is no question on jurisdiction or proceeding further of the election commission. And they have taken this position. Kindly permit me, the last 5 lines in para D. Who is the Shiv Sena? Who is the Shiv Sena? The moment this question comes, my lord, it is also our common case. Exclusive jurisdiction is of the Election Commission of India. And they said so. And once they said so, my lord, there was no occasion for them to file any substantive writ petition questioning that position, because they can't live with the inherent contradiction in their stand. Now, my lord, if that is the position, will your lordship permit an interim application to be filed in some other writ petition? Kindly see who is the Shiv Sena. That is the domain of Election Commission. Admittedly, recognition of Shiv Sena and leadership by so and so has been endorsed by the Election Commission, and there is no dispute. Now, kindly see para 36, page 10, next page. This is a part of the rejoinder, para 36. After our stand was filed to this writ petition, the file the rejoinder. So, original position is the moment question arises, who's Shiv Sena? Election Commission. Kindly see 36, third line. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the first place. So what did I came for? I came for extension of time, which is in violation of the rule only 2 days, and I asked for 2 weeks. 2 weeks is granted by your lordship. Compliance of natural justice. That has nothing to do with either the office of the Speaker or the Election Commission of India.
All right, Mr. Maninder. Yes.
Let us hear
Only
the
2 minutes. Kindly come to 2. Kindly come to 2, but the 10 schedule. 10 schedule. Only about 2 minutes and I'm done. All judgments are cited. I have nothing for this hearing. But kindly come to 2-1. There is no political.
Mr. Maninder Singh, it is read and re-read and re-read.
Only 1 minute I will take. You're not.
Otherwise, we will have to hear Mr.
I will just clear it in 1 minute. 2-1A. 2-1A and 2-1B. The last word of political party and in the contrast in clause 3.2 which is deleted and clause 4.2 of the merger and the split, it's legislative party. Now in this, who is the political party and who can issue validly in law direction to the political party? Unless that question gets decided, there is no ambiguity in that regard. Speaker has no jurisdiction. And that is why the order is that once such question arises, EC will decide first. And that is the writ petition. Ground D and para 36 in rejoinder. Grateful, Mullah, I am deeply obliged.
Thank you. Yes, we did, Nani.
Very brief. I realize your lordships are very keen to hear a detached voice rather than partisan interest. So I'll just state my proposition. My learned friends have dealt comprehensively with the distinct jurisdictions of the Speaker and the Election Commission. One decides disqualification of MLAs in the House. The EC decides intra-party disputes. Now, the question of disqualification, and what instance I hope to answer my Lord Narasimha's query. The question of disqualification under the 10th schedule is governed by a mandatory procedure. Particularly, there has to be a notice, a hearing, rules of natural justice, and a reasoned order. Although there is no concept of potential or deemed disqualification, it has to be actual, not a deemed fictional one. The entire case of the other side, trying to link disqualification with intra-party disputes, is based on a disqualification which has never happened. There is no such question of a deemed disqualification. That fiction is the fiction of the other side. Thirdly, allied to this question is that the deputy speaker, in this case, there was no speaker because the then speaker had resigned since 5th February 2021. But the deputy speaker in this case was disqualified from embarking upon the adjudication procedure because it had been brought to his notice that he had lost the confidence of the majority in the House qua his position as deputy speaker. Now, my lord, this is not just Navam Varia's case. This is actually a mandate that when your own position as deputy speaker, i.e., the adjudicator of disqualification, is under question, then it is not just Navam Varia, they amplified it. But it's Article 181 of the Constitution's mandate. And I'm not going to read it out. Your Lordship will just note that Article 181 says this, that when the Speaker of the Deputy Speakers, a majority is itself question, he must desist from the adjudication process. No, it's not just Nabam area, which is one of the questions of law propounded. Nabam area does say so. And we're having a second look at it, but also Article 181. Remember, two more propositions.
Yes.
Any link, in my respectful submission at the outset, the distinctive jurisdictions of the Speaker and the Election Commissioner, is determinative of this matter. Now, that's almost conclusive. But my lord, any possible link between disqualification and the powers of the Election Commission to deal with inter-party disputes has been snapped by the very important event of the Chief Minister resigning on the 29th of July 2022. On that night he resigned. Sorry, 29th July.
June.
Sorry, June. 29th June. I'm so sorry. 29th June. Now, my lord, when that happened, a government fell. Nothing that happened thereafter, after he resigned, was a consequence of what happened previously. When the Chief Minister resigned, what kicked in was a process which was obligatory on the governor of the state. The governor had to then decide whether he could find a stable majority, which in turn necessitated discovering that person who commanded a majority of the House, and that person could therefore offer a stable government. That the governor proceeded to do. And because this is the mandate of Rameshwar Daya of 2007, I'll give us the citation. Rameshwar Prasad. In that judgment, the court said when the governor is setting about the task, and it's paragraph 161 in particular, what you just know, when he is setting about the task, his constitutional obligation to form a stable majority, he has not to be deterred by any questions of potential disqualification. So the governor did that, and a new government came into existence. Now, my lord, when a new government comes into existence, a stable government, one more article kicks in, and that is Article 178. Please see that.
To give the citation of Rameshwar Prasad.
Yes. 2006 to SEC page 1. Legislative Assembly of a state shall, as soon as may be, choose 2 members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member. Now, on the new government being formed, an election was held for a new Speaker. This was the mandate of 178. A new Speaker now has taken, and he took office after a vote. They participated in that vote and they lost. There is now a new Speaker. Any questions of disqualification, and my lord, the Deputy Speaker only performs the task of the Speaker when the Speaker is not there. Once you have a Speaker, any question of disqualification now goes to the Speaker. There is no need of disqualification, and they want to run away from the question of actual disqualification because the new Speaker has come. So, in short, my lord, I will pay.
Thank you.
Mr. Datar.
Well, just one question of Justice. Well, there is a judgment of the division bench, a recent judgment of the division bench, which goes into this between 10th schedule and the election commission. It's a division bench
Of
the Kerala High Court.
what is the citation?
Yes. Okay. It's in the compilation. It's 2021 4 KLT SN 33, page 51. But it's an I compilation and it's judgment number 7 in our compilation of it. Particularly paragraph 76, the last paragraph, it's the one case which decides both the issues. It's the first case I've seen where both the disqualification as well as the inter-party dispute was concerned, and the impact of each.
Mr. Solicitor, you want to?
Sir, only 5 minutes because
Yeah.
I appear for the governor. Therefore, my role is different. In my role, I have already played and if required, Lord, I may play, but only question your lordships in the today's hearing required to answer is this. But when Article 324 was framed, just giving a little background and 5 minutes is broadly outer limit. When 324 was framed, so there is a beautiful discussion which I will not read, I will pass it on, where Dr. Ambedkar examined what was the purpose of 320. And one of the main purpose was that certain political questions may arise as against the constitutional questions. And those political questions, there has to be an authority who, apart from conducting election, will also decide. And that is the election commission. Your lordships would also not possibly be able to go into the political thicket in case of president rule, etc., in a different fact situation which is not arising. The only question, which needs answer for the today's limited hearing is, can your lordships take a call whether this faction is right or another faction is right? That answer, my lord, will decide today's hearing. Answer in my respectful submission, no. This is essentially a political question. There are rules framed by the Election Commission of India as to how that question is to be gone into and decided. Because this is not for the first time that such a situation has arisen. That within the party, two factions claim that I am the original party. Somebody will have to go into that question. And that somebody, under the scheme of the Constitution, is only the election. Third question, whether both would be overlapping. In other words, suppose the question of disqualification is held against the client of Mr. Kaul and Maninder Singh, would it have any impact on the exercise to be undertaken by the Election Commission? The answer is no. Suppose the Election Commission takes the call that this faction is the correct faction, represents the original political party. Would that have any impact on the decision to be taken by the speaker? The answer will be no, because your lordships are assisted on both spheres. Yes. Here the speaker will decide that whether they voluntarily gave up membership, etc. They would argue that we are within the party, but within the party there is a freedom of speech and expression which we were exercising. That is for the speaker to decide. But even as disqualified MLAs, they would still continue to be members of the political party because there is no disqualification from membership. So the Election Commission is merely deciding which group represents the original one. So, right now, for the limited purpose, my respectful submission is that let the Election Commission discharge its duties.
Thank you, Mr. Datta. Mr. Datta.
My submission is already on that the functioning of the Election Commission is completely different and independent from the role of the Speaker in the scope of the 10th schedule. In fact, Lordship sees the 10th schedule. The heading refers to C Articles 102 and 191. We'll have to first go to those articles. Lordship just takes 10th schedule. This Articles 1022 and 191(2).
Yes.
And bro, since we are referring to a state assembly, I will confine myself to Article 191. So, Lordship, but I want to show the constitutional provisions and the statutory provisions which show that the Election Commission's role under the Representation of People Act 1951 is completely independent and completely different from what happens in the 10th schedule. If your Lordship now comes to 191 of the Constitution, Lordship will note, along with the insertion of the 10th schedule by the 52nd Amendment, they also inserted Article 1022 and 191(2). And if your Lordship sees 191(2), a person shall be disqualified from being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified under the 10th schedule. Now, please come to 191(1)(a). The Lordship kindly sees, person shall be disqualified from being chosen and for being a member. So, my lord, there are two types of disqualifications. A threshold disqualification, where you can't even become a member.
And during the
And second, during. But in the company law, they use more elegantly. They say disqualification and vacation. You become a director, then you vacate the office. So when we say disqualification for being, it actually means disqualification from continuing as a member of the house. Now, Lordship will just see A, if he holds any office of profit, B, if he's of unsound mind, C, if he's an undischarged insolvent, and D, if he's not a citizen of India and has voluntarily acquired citizenships, etc. And E, if he's so disqualified under any law by or any law made by Parliament. The Lordship will find that there are 4 constitutional disqualifications, which is A, B, C, D. The 5th constitutional disqualification is 191(2). And if your Lordship sees what is 191(1)(e), if he is so disqualified or under any law made by Parliament, Lordship has to look at the Representation of People Act 1951. But I will be basically referring to the Constitution and the Representation of People Act, so Lordship will just keep these bare accents. Now, if Lordship just sees the index, the table of contents of the Act, of the Representation of People Act 1951. My Lord will find that as far as the Representation of People Act is concerned, please see the table of contents, the index will give you also the architecture of the Act. Chapter 1 and 2 talk of qualifications. And my Lord will kindly notice that chapter 3 and 4 deal with disqualification. Yeah, it's a very small act.
I just, in an order yesterday, we said 50. I just told him I had a recollection that I did
Yes.
50.
In fact, the Statement Office and Reasons say that 50 Act is very short, so we have to expand it further.
Yes.
So, Lordship will kindly come to chapter 3, just the headings. Definition, disqualification for conviction, disqualification ground of corrupt practices, disqualification, etc., etc. And chapter 4 is disqualification from voting, where you are a member but you can't vote. Now, what I'm submitting is,
Yes,
the Parliament and the Constitution has consistently made the difference between what are disqualifications under the Constitution and what are disqualifications. As far as the Representative People Act is concerned, the authority to decide is the Election Commission. Actually, I'll come to 191. The President will decide, but he will take the opinion of the Election Commission. If your Lordship now, so the point I'm making is, the disqualification given in the Representation of People Act 1951 is a completely different thing. The role of the Election Commission, being a constitutional body, is clearly demarcated, and it is neither hedged nor restricted by the 10th schedule in any manner. If your Lordship now comes back to 191, the next section 192, Article 192.
yes.
If any question arises, 192. And Lord, this is equal to 103. Lord, just makes a note. Parallel provision Parliament is 113. If any question arises as to whether a member of a house of a legislature of a state has become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the governor and his decision shall be final. 2. If before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinion. So disqualifications in clause 1 are constitutional disqualifications plus under the Act. These are decided by the governor, but he will take the opinion of the election commission. Now, yeah, and Lordship will kindly note the governor shall obtain the opinion of the election commission. So he has to. So the Act very clearly demarcates the role of the election commission as quite distinct, separate, and the parameters are prescribed. Now let's go to the 10th schedule. Lordship will first see para 2C is original political party. Original political party. But if my lord sees the definition in the Representation of People Act 2F, my learned friend, I think somebody referred to the room, but if your lordship goes to the Act itself, the Representation of People Act under 2F,
Political party.
Political party means a political party which is, once again, this opens into the 50 Act.
Mr. Maninder Singh referred to that.
He referred to the rule.
To the rule. Identical.
Identical.
Symbol order.
Yes, I think in the symbol order it's 2H and here it is 2F. But the point I'm making is the purpose.
2H.
Yeah, 2H in the rules, 2F.
2F corresponds to 2H.
Now, it talks of political party means an association or body of individual citizens of India registered with the Election Commission as a political party under Section 29 capital A. And just see 29 capital A for a minute. Registration with the Election Commission of associations and bodies as political party. So Lordship will see, my lord, it's not necessary to be a society or a trust. It can just be what we call an income tax, an AOP, or a body of individuals. The association of body of individuals, citizens, calling itself a political party and intending to avail itself of the provisions of this part, shall make an application to the Election Commission for its registration as a political party. Now, my lord, my humble submission is the need to call, when you talk of original political party, that means there is something which is original and something which has come later. That must be because of the provisions of para 3, where a group of people could split and form a separate party. So that could perhaps be the reason why they use the word original political party, which means the political party contemplated and registered under Section 29A. That could be the original political party. And para 3, where they say that if more than 1/3 people split, they could sit as a separate member. And in fact, the 91st Amendment says that this bulk defection is causing harm, and therefore they decided to do away with para 3 completely. So my submission is original political party must be understood to be, in my humble opinion, the 2F led by 29A party. That is the party which is registered with the for the purpose of anti-defection. They said that even if more than 1/3 members go, it will not amount to a defection. That has been done away with. So now basically original political party will now be relevant only in the context of merger, which I will come to later. But for the purpose of us, that's the meaning of original political party. Now what is legislature party? Legislature party means, Lordship sees the constitution. Legislature party in relation to member of a house belonging to any political party in accordance with provisions of paragraph 2 or paragraph 4 means the group consisting of all the members of that house for the time being belonging to that political party in accordance with provisions. Therefore, if the political party is a larger set, then the legislature party is a subset of members of that political party who are also being elected and now form part of the house. It is quite possible that you can have a political party with no legislature party. It's not that every political party has MLAs and MPs. So, legislature party is a subset of the original party That is, every legislature member, or every member of the legislature party will necessarily be a member of the political party. This is the now coming to the role. Now, what is the question here? As Malad just put it, the batting order. Suppose there is a case of a split in the house in this particular case. But I am arguing a case independent of any kind of, as a general principle of law, what is the role of election commission? Suppose there is a defection crisis in any assembly or parliament and the matter is sub judice either before the High Court or the Supreme Court. Does it stymie? Does it stop? Does it interdict the functioning of the election commission? Is a question which a lordship has to answer. And my humble submission is, when do we avoid parallel proceedings? We generally avoid parallel proceedings
when the jurisdiction is concurrent.
When the jurisdiction is concurrent, and typically there is a higher forum and a lower forum. And as a general group, the subordinate forum will yield to the higher forum. So if a matter is pending in the High Court, say for example in a tax matter, and you lordship gives a notice, then typically the officer will not proceed because he will await the decision of the High Court. So parallel proceedings come where the jurisdiction is concurrent, and there is a possibility of the possibility of two authorities coming to contradictory conclusions. The second point I would request the lordship to kindly consider: 10th schedule is legislature or member specific. Regulation 15, para 15 of the symbol order is party specific.
So the issue of disqualification would really relate to the membership of that house.
Of that house, that's what why there are two
A
states.
particular state
Yes.
legislature, or if the case may be one
Because
house
yes,
parliament.
191(2) says you will be disqualified from member of that house. It doesn't say anything about your political affiliation, political party membership.
Para 15 is really agnostic on
Yes.
the legislature because
Yes.
that is irrespective of whether there is or there is not any
In
disqualification.
fact, I mentioned that political party may not have any member of a particular house also, or it may have members. So what we are concerned is, now if your lordship sees the what I call the structure of a 10th schedule, first one is definition, 2 is the substantive, what is disqualification, 3 and 4 are exemptions to that disqualification, that is 1/3 member and merger. So 2 is the bar, the disqualification, 3 and 4 are exceptions. 5 is also an exception where it says that if you're a speaker, it's very unique for a speaker, if he gives up his membership, then when he comes back, he doesn't get disqualified. 6 is the procedure, which came up for consideration in Kyoto, and 7 are the rules. So if a lordship kindly sees, every para in the 10th schedule refers to the disqualification of a particular member. The lordship, para 2A, for example. Here is a case where 2A of the 10th schedule. I'm trying to say, Manoj, that the fields are completely different. The territory is completely different, so to speak. Ballot kindly comes to 218. A person who has voluntarily given up his membership. Now, Manoj, it is absolutely common sense that if a person is given up his sense, he's now going to file an application in clause 15 of the symbols order. People who come for the symbols order are saying, look, we are in this party, the rival group is in this party. Please decide who's the real party. So 218 will never apply. What is 218? You violate the whip. So the role of disqualification is basically a person who gets elected on a particular ticket, then leaves the party and comes to it, then you get disqualified.
The only point really, Mr. Datar, is that the issue of giving up the membership of a political party within the meaning of 21A
Yes.
is not confined to your activities within the house.
Yes. In my submission, Lord, I would submit that will partly depend on, because what I'm submitting is If a
Because
lordship,
voluntarily giving up the membership of a political party is not confined to what you do within the folds of the House. Unlike 2(1)(b), which is votes or abstains from voting in the House.
yes,
But 2(1)(a) is much broader.
true.
Voluntarily gives up membership of a political
No,
party.
no, I'm sorry. I absolutely no
And
problem with that.
therefore, the Speaker's power to determine that is not therefore confined to what takes place within the fold of the House.
Lordship will see there are case laws which say, what is the meaning of voluntarily giving up membership? There are judgments which say, if a particular member of party X has attended all the meetings of party Y, he has participated in the functions of party Y, then has he given up his party or not? So in some cases they say, yes, it's amongst giving up membership. But that's really outside the scope of this reference. That's why so when you say voluntary, Lordship is right. That's why under clause 6, the speaker is called upon to say that Mr. X, he attended the rallies of this party. Not the reported judgments are there, I can circulate them. He attended the rallies of this party. He attended the meetings of this party. He was seen in this particular party. The Supreme Court has said no, but his name is still continuing in the register of members, therefore he has not given up. In 2 cases, they said this itself indicates that he has given up his membership. So is it it can be impliedly giving up also, physically actually giving up also. But what I'm submitting is,
but one thing is very clear that 2(1)(a) as well as 2(1)(b) is member specific.
member specific.
15 is not in that sense member specific. It deals with a faction as to whether a particular faction represents a political party.
Now, Lordship will come.
It refers to a collective group as to whether that represents.
Yes. Now, Lordship will come. Yes. So, what I'm submitting is, paragraph 15 basically refers to the collective right, the collective party. Who is the real party? And if your Lordship now comes to paragraph 15, which your Lordship saw a number of times, I won't go through it again. And if your Lordship has seen Sadiq Ali several times, I won't repeat it. But the first 2 paragraphs are very interesting. How did this problem straight away come about? Because Nijalingappa came to the Congress so, and Jagjeevan Ram was Congress chief, and we've all gone through the controversy in those days, the Congress so, the Congress, etc. And then the argument was that the Congress who had majority in the Congress Working Committee. Lordship, kindly just your broad outline of that case.
Sadiq Ali is of which year actually?
1975.
75.
But this split took place in
1969.
Yes.
We were, so in that sense, Sadiq Ali was doing a bit of a postmortem on what happened.
No, but what happened was because Justice Sena remarks in an abnormally prolix order. The prolix itself is abnormal, but his Lordship says abnormally prolix order of 437 pages. The Election Commission has drawn. There, what happened was, Lordship will just keep on just 2 points. Lordship will know. Sadiq Ali deals with 72 Supreme. Sorry, it's Sadiq Ali says 72 4 SCC 662. Sadiq Ali says the Election Commission went by 2 tests, and that Supreme Court approved. One was the test of majority. Test of majority way Parliament and individual houses. They took the strength of the Congress in the Lok Sabha, in the Rajya Sabha, in the individual houses, and they said that out of these number of MPs, X are in the Jagjeevan Ram faction. Why are in the Nijalingappa faction? They go statewide. But you want to see that, I can show that later. That's the break. Then they say, at the All India Congress Committee, Working Committee, where more than some 2,000 odd members were there, a large majority voted for this particular group. And therefore, the election came to the conclusion that the actual Congress was the Congress J and not the Congress O. And the court said nothing wrong with it because they have gone by test of majority in this. The point is not what we are about. The point is, Election Commission is free to decide as to how it tests the majority. And by and large, what they're doing is, and I've got cases in my compilation. We had recently problems in Tamil Nadu where who was the correct member of the All India NDTV. Hearings took place, they came right up to the Supreme Court. And what the Election Commission they take a complaint, ask both parties to give their submissions, then evidence, affidavits, etc. are admitted, and then inquiry is done. Please see my notice under paragraph 15. I am humbly submitting that this notice has nothing to do with the election. Chapter. Lordship will kindly see out. Yeah, please see the page. Please see my notice page. No. The notice, section 15 notice.
Para 44, page 44.
Yeah. Lordship will see para 40, page 44 of R4 compilation, volume 1. 22nd July 22.
Documents.
Yes. Document number 9. My lord is gone.
Document number 9.
What is it? What
It's
is
in the
it?
Sadiq Ali compilation.
No. It is the compilation of respondent number 4. Volume 1, respondent number 4, compilation of documents and rules. And this is document number 9.
Notice
Yes.
of 22nd.
22nd, your my lord is right. 22/7/2022.
Page number?
Page 44. So the pages are coming at the bottom.
Yeah. We have got total 118 page.
Yes. So Lordship will kindly see the notice is sent to both and then subject so and so. After the preamble, kindly come to para 2. The commission is in receipt of communications as delineated below. She is so and so member of parliament and secretary of party on 25/6/2022 intimated the commission about the alleged anti-party activities carried out by some of the MLAs under the leadership of so and so, and objected to establishing any political party using the names Sena or Bala Sahib. Anil so and so forwarded 3 letters dated so and so, and so he gives a comment. Then Sri Anil so further email an affidavit of so and so. Now kindly come to E. Sri Eknath Shinde on 19/7/22 filed a petition before the commission titled as so and so on the para 15 of the election symbols to declare the group led by Eknath Shinde as Shiv Sena and allot the party symbol of bow and arrow to the group. Eknath Shinde, the above petition, interior mentioned that. Then he goes on to 1, 2, 3, 4, 5, 6. Now please come to para 3 at page 47. Now this is the standard format we file whenever we get a complaint. We say who has made the petition, what is the gist of this complaint, what is the other side. Please come to para 3. Para 15 of the election symbols and reservation allotment order 1968 provide that when the commission is satisfied on information, your lordship see para 15, I won't read it again. On due consideration of the totality of information available on record with the commission as summarized above, the commission of this of opinion that there are 2 rival groups in Shiv Sena party, one led by Uddhavji Balasaheb Thackeray and the other led by Eknath Rao Sambhaji Shinde. Each group is now claiming to be the party, and therefore the matter requires a substantive determination by the commission under para 15 of the election symbols. In order to place both the rival groups on even keel and to protect their rights and interests, and going by the past precedents, the commission has directed the documents submitted by the rival group be exchanged and the reply written submissions be invited from the 2 groups. The steps envisaged under para 15 proceedings prior to the hearing rival groups they require both rival groups to submit the respective documentary evidence of the support claimed by them, the organizational and legislative wings of the parties. Accordingly, Commission has directed both the group to furnish written submissions and their respective documents to support their claims by 8th August 2020. But when the matter came up, I told the court that this is just the first step. There is no need to stop me. Let all the inquiry go on, inquire the matter. But then the court said, please furnish documents you asked for. Now, if your lordship sees the notice, it has got nothing to do with the membership of any person of the party or of any house. There is an MP or an MLA. Nothing. Secondly, my lord, by submitting this application by respective sites, none of the provisions of 10th schedule are attracted. Because 10th schedule disqualification is limited to 218, 21B. So my submission is, as somebody mentioned, para 15 is like the inner party democracy. Suppose as the party grows, there are bound to be groups, bound to be factions, and ultimately who claims superiority? There is no floor to test the house. So only way election can do is to get documents, get affidavits, listen to the parties, and then decide. Now, Lordship will just see how we have done it in one case from Tamil Nadu. I think that Anna DM.
I don't think we need to go into the issue.
No, what I'm saying is, because Lordship will see, number of advocates have appeared, numerous documents have been filed, hearing has been conducted. Yeah.
So Datta, you have already said so in your paragraph 3, the
Yes.
procedure to be followed by the election commission.
Correct.
You have already stated so.
Thank you, Mr.
Yeah.
Datta.
So my humble submission is not only in this case, but as a general rule, my humble submission is whatever happens on the floor of any particular house of parliament, that will be completely independent. It will not impact the functioning of the election commission in any case at all. Two things can happen. Either Lordship may allow the petition or dismiss the petition. The result of the paragraph 15 order will be completely independent of that. Whether a person is disqualified or not disqualified. He doesn't cease to be a member of the political party. And we have to go by the majority of the members of the political party, not of the legislature party. The impact of 10 people on the legislature party, but not on the political.
Yes.
Thank you.
Thank you, Mr. Datta. Yes, Mr.
My very friend is right. These two, 10 schedule and para 15 operate in different silos. Then he's right. That's what your lordships have to decide. My lord made a very important and significant comment. A lot of these issues in respect of voluntarily giving up members of the party doesn't happen in the house. You go to Gujarat, hobnob with the opposition. Then you go to Guwahati. From there, you are sending notices. Then you accompany the leadership of the BJP to the governor. All this is not within the house. All this is outside the house. And the speaker will have to consider, for the purposes of coming to the conclusion, whether you have voluntarily given up membership of the party, not the house. It is because of that that you are disqualified with the house. Giving up membership of the party outside the house amounts to disqualification within the house. So you can't say one is different from the other. What happens in the house is unrelated to what happens outside the house. And the election commission can't say, I'm not concerned with any of that. Number two, Manoj, in paragraph 21B, if you vote against the whip, you will be disqualified not just under 21B, but also under 21A. Once you violate the whip, Manoj, not only have you expressed yourself that you are voting contrary to the whip, you are also saying, I'm no longer a member of your party, but I'm not bound by your whip. That's the constitutional position. With the greatest respect to my learned friends, Manoj, they are completely misled, Manoj, the decision of this court in Rajendra Singh. Let me just give you a notice briefly what it was. Of the BSC. Joint hands with the Samajwadi. Now, there were 109 members of the House. The speaker gave notice, nothing. He did nothing. After a few weeks, 24 more of them joined. So they became 37. Then the speaker said, this 37 is 1/3. And because this 37 is 1/3, therefore they are protected under the 10th schedule, because at that time paragraph 3 was there. This court said no. You have to decide on the day when 13 members went to the state. They were at that time not 1/3. The speaker wrongly allowed 1/3 to develop to
give protection to the 10th schedule under paragraph. Therefore, the disqualification relates back to the time when the 30 members approached. Speak. That's one part of it. My argument is completely wrong. That is unrelated to the issue of giving up membership of the House. When paragraph 3 was, before it was deleted, very interesting. It is integrally linked with the political party. Kindly see our compilation of statutes. Paragraph 3.
You can read it out, Mr.
Sorry. He says not given to the court. Sorry.
That's okay. And it's not in the footnotes. Otherwise, normally it's in the footnotes.
Yeah,
of the,
also looking at the
but, this footnote doesn't have it actually.
I'm sorry.
No, that's all right. Just read it.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction. Kindly see whether the correlation of this with paragraph 15, which has arisen as a result of a split in the original political party. It's 115 of their compilation. I will look at it. Better what we did.
You can.
And such group consists of not less than 1/3 of the members of such legislature party. He shall not be disqualified. So what does it say? A member of a house who claims that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party. So when the speaker decides in the paragraph 3, Rajinder Singh Rana says, merely because you make a claim is not enough. The speaker will have to prima facie decide that there has been a split in the original political party. It's not a question only of the legislature. And that is reflected in paragraph 37, 36 and 37. You just read 37 because that's why I wasted time with it. This is 1074 SCC model I have. In their compilation is 192. Para 37. I'm reading 36 and 37. 192 models probably. So, 219, my lords. Plus 219, they are quoting Jagjeet Singh Miller's paragraph 69. The lords, my lord, just that's in italics, not in italics, but in intention. My lords have that. Apart from the above, the acceptance of the contention that only a claim is to be made to satisfy the requirements of paragraph 3 can lead to absurd consequences, besides the elementary principle that whoever makes a claim has to establish. It will also mean that when a claim as to a split is made by a member before the speaker, so as to take benefit of paragraph 3, the speaker, without being satisfied even prima facie about the genuineness and bona fides of the claim, has to accept it. It will also mean that even by raising a frivolous claim of split of original political party, a member can be said to have satisfied the stipulation of paragraph 3. The acceptance of such a broad proposition would defeat the object of defection law, namely to deal with the evil of political defection sternly. We're of the view that for the purposes of paragraph 3, mere making of claim is not sufficient. Prima facie proof of such a split is necessary to be produced before the speaker so as to satisfy him when such split has taken place. This is contrary to what my learned friend argued, completely contrary. Now see 37. Thus, in the above decision, it has been clarified that it is not enough that a claim is made to have a split in the original political party, in addition to showing that 1/3 of the members of the legislative party have come out of the party, but it is necessary to prove it at least prima facie. Those who have left the party will have prima facie to show by relevant materials that there has been a split in the original political party. And my learned friend argued that no, in Rajendra Singh Rana, they have said we are the original political party is not concerned with the split in the legislature. It's just the contrary. The argument, therefore, that all of the other than 37 MLAs required to do so was to make a claim before the speaker that there has been a split in the original political party, and to show that 1/3 of the members of the legislative party have come out, and they need not produce any material in support of the split in the original political party, cannot be accepted. The argument that the ratio of the decision and justice required to be reconsidered does not appeal to us. Even going by Ravi Naik, it could not be said that the learned judges have held that a mere claim in that behalf is enough. Now, what's important here, and this is the significant part, having done away with paragraph 3, now consider the consequence. Now there is no question of majority minority. There is no question of 1/3, 2/3. You have to abide by the discipline, and the only defense is paragraph 4. To say, therefore, the whole argument is that I am 40 or I am 30 or I am 20 is neither here nor there. For the purposes of the 10th schedule, this is irrelevant. So what has happened is, I am the party, I am the Shiv Sena. I am recognized by the speaker as the Shiv Sena. You are members of the original political party who are represented in the House. You have done an act contrary to, in collaboration with others belonging to the opposition party, done acts which amount to voluntarily giving up membership of that party. Now, if this is decided by the speaker in these petitions, what will it relate back to? Relate back to what happened after 21st of June. Para 34 of this judgment clause. The act of disqualification occurs when a member voluntarily giving up his membership of the political party or at the point of defiance of the way wished to it. Therefore, the act that constitutes disqualification in terms of para 2 is the act of giving up or defiance of the whip. The fact that the decision in that regard may be taken in the case of voluntarily giving up by the speaker at a subsequent point in time cannot and does not postpone the incurrence of disqualification by the act of the legislature. It will therefore relate back. Now, if it relates back to us, then it will relate back to what happened between the 21st of June and thereafter. What the Election Commission is seeking to do is to decide the status of the party, so-called party, on 19th of July. But what will happen on the 19th of July thereafter has nothing to do with what's happened before. Because what has happened before is that they have given up the membership of the party. Let's ask the question, the very important question that we threw him out of the post. But let's see our letter. Volume 2. First, we show the letter to the Election Commission.
Now, let us kindly see the letter we wrote to Sindhi on the 30th of June. It's much before 19 July. At page 321. Convenience compilation, volume 2, page 321.
Yes.
Dear Mr. Shinde, you have been indulging in anti-party activities and have also voluntarily given up membership of Shiv Sena. Therefore, in exercise of power vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So, Malas, I tell him that you have already by wax given up membership of the party. So it's not a question, Malas, of removing him from the post. Now see the letter we write to the commission at page 333. This is on the 1st of July.
Yes.
Second paragraph. As you are aware, Eknath Shinde has indulged in anti-party activities and has voluntarily given up.
1488.
1488.
PDF.
As you are aware, Shri Eknath Shinde has indulged in anti-party activities and has voluntarily given up membership of Shiv Sena. Consequently, he was removed from the position of Shiv Sena leader in the party organization set up by Shiv Sena Paksh Pramukh Shri Uddhav Thackeray in terms of party. Just to mention that he was not an elected member in the party organization. He was nominated by the leader. Uddhav Thackeray is the president of the party from 1990 to 1923. I still remain the president of the party. Even now. Sorry, 2018 to 2023. As per the records of the election commission. So I remove him. He was a nominated member. I remove him. I tell the commission and I tell him that you have voluntarily given up membership of the party. So it is my case, Malas, that he is not even a primary member of the party. Not by virtue of the fact that I have thrown him out. By virtue of the fact that under the 10th schedule, he has committed acts in terms of which he is disqualified by virtue of 218. My learned friends are saying that this has nothing to do with the election commission. As a matter of constitutional law, how is that possible? In other words, the election commission will decide and will presume as a matter of law that he continues to be a member of the party. Whereas this under the 10th schedule, by his acts, he is no longer a member of the party. So, Manas, how is that possible to say that no, these are two different cycles? Now, Manas, and therefore, Manas, I am saying because there is no defense now available under the 10th schedule at all as far as paragraph 3 is concerned or any other paragraph is concerned. The only defense available is merger. And in the context of merger, Manas, if your lordship looks at paragraph 4, just give me a minute. Very interesting. Should not be disqualified under subparagraph of paragraph 2, where a regional political party merges with another political party. And he claims that he and any other members of the original political party have become members of some other political party. So, Manas, if he is a member of the Shiv Sena and Shiv Sena merges with somebody else, the stand of Shiv Sena is effaced. He is no longer Shiv Sena. So he merges with another party, or he has another party merge with him and he forms a new party.
the new party or the merged party becomes his original political party. I hope I made myself clear.
Yeah.
So it becomes his original political party, so he's washed his hands off from himself. That's the consequence of paragraph 4. Then he can't maintain a petition under paragraph 15. Because he's either merged or he's found a new political party. And those who are left behind, that is, who are less than 1/3, because 2/3 makes for those belong to the original political. In this case, us, of course, in the absence of a merger. So, therefore, the nomenclature of the original political party, which was attractive when they were first elected to the House, they've lost that in the paragraph. Now, see what my learned friend read. He said, please read the last part. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of the House shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Naturally, because we are now talking about formation of a new party. Therefore, you are no longer the original political party. This will take a bit of time.
Mr. Sibal, you can conclude your argument.
No, you are in rejoinder council. No, that cannot be tit. No, that cannot be tit for tat. That he has taken 2 hours.
All right, Mr. Sibal, you can deal with the judgments. You can tell us what the point of distinction is. What we've been noting along is you go along and what the point of difference is.
I have no problem. I can finish it 10 minutes. Now, therefore, now let's come to paragraph D.
Paragraph D or?
Okay. Our my colleague Maninder Singh cited paragraph D of our petition.
Okay, the ground. Ground.
Ah, yes, the grounds. What your prayers.
What I was saying is there are certain judgments that have been cited that are wholly inapplicable. I just want to point out that there are 2 other judgments. It's all right. Read the whole paragraph.
No,
Let's read the whole paragraph.
Ground D of page 8, right?
Now, because and children. That's the point, Manu.
But that will be considered, Mr. Council, at the time when we consider the question of disqualification.
But if you lordship allow the election commission to go on and hold, and that's the point, Manu. Either your lordship says one has nothing to do with the other, and if your lordship is saying you will consider it at that time, that means that has something to do with the other.
And
I'm not saying I'm only saying, Miller. He says these are great repercussions because in this situation, then X number of people of a political party who are in power can be named away. Governor will give them votes, and we'll go to the election commission and say, "You declare us the simple Millers." And that's the consequence, which is sought to be prevented by taking away the third paragraph, paragraph 3 of the 10th schedule. The whole purpose of taking away paragraph 3 is let's not have any splits. Then paragraph 36 minutes. Also read it half of it. I'll just read that minutes.
Page 10. On the contents of paragraph 24 to the 24 to 32 are denied. It is submitted that really claiming the support of a majority of SSLP cannot be looked at in isolation. If the delinquents were so keen on a change in party leadership, they ought to have approached the Election Commission in the very first place itself, having committed a series of anti-party activities culminating in the blatant violation of Whip 37 as well as on 47, and having read the writing on the wall as to their imminent disqualification from membership of the assembly, the splinter group has now rushed to the Election Commission to claim that they are the real Sena. Well, this is what they did. They did it on the 19th of July, knowing full well that the writing is on the wall. Then, my learned friend cited two other judgments. But a Kerala judgment where there was no disqualification.
2021 4 23, he said at page 50.
Well, then,
But he didn't read it out.
Let's see, Palani what does he cited?
Palani
Well, that is a pure issue of why the matter was pending before the commission. I myself argued it. The question is, who should the symbol go to, or should it be frozen? Interim symbol, which has nothing to do with the tension. Swami had nothing to do with the tension. Matter was pending before the commission. There were rival claims. And the question was, who should get in the interim symbol? What has that got to do with this issue? The third judgment my learned friend cited is the Kerala judgment. So by that, my colleague.
That Mr.
Jetmalani cited. Para 4,
He really just gave us a citation.
He has no doubt.
No, he said that this is the first time the court has decided.
Page 51.
Yes, now, I just note para 6 of that judgment says the learned single judge has also failed to appreciate the fact that even when the writ petitioners claim that rival groups exist in the party and their group is the party, no petition under the 10th schedule has been preferred. It's not a case of the 10th schedule at all. Para 6 at page 172, 3 minutes. Para 6.
At page 173.
Yes. It's not a case of any application also for disqualifications. Then he cited Kanhaiya Umar. Now, Kanhaiya Umar, brothers, it is a writ petition challenging the power of the commission under the symbol law. The violence of the symbol law. What has that got to do with disqualification? That's Kanhaiya. Then well as all party his leaders conference, brothers. That was a case. The election commission is a tribunal for the purposes of 136 before 1985.
Yes.
Now let us kindly see what the notice of the commission is to us. Page 701. Compilation Brothers document, volume 2. Kindly see paragraph 4 on due consideration. This is their notice. You also have that? That is 701.
That is document number 9.
Yeah, on due consideration of the totality of information available on record to the Commission, as summarized above, the Commission is of the opinion that there are two rival groups in Shiv Sena. So he's already assumed that there are rival groups in Shiv Sena, when the whole question is whether these are part of Shiv Sena or not. One led by Uddhav Thackeray and the other led by Eknath Shinde. So you assume this, Malad, on what basis do you assume this? And each group is now claiming the party. That's not my thing. I am saying he's no longer in the party, he's voluntarily given up. How does the, on what basis does the election commission come to that? Assume that fact. Matters require substantive. Now see next paragraph. In order to place both the rival groups on even keel, but this is very strange. Both the rival groups on even keel. Where does he get that from? So what the election commission is doing is, I don't care what's happening under the 10th schedule. I'm not bothered what's happening under the 10th schedule. Even if you are deemed to be disqualified, even if you are voluntarily given up membership of the party, I will treat you on an even keel. I will assume you are still a member of the party. Whereas he can't, the election commission can't assume that. We have already written to the election commission that look, he is no longer a member of the party. He is voluntarily given up. So on what basis does he say on even keel? And to protect their rights and interests, and going by the past precedent, Commission has directed that the documents submitted by the rival group be exchanged and replied. Even then, then was interesting. The steps envisaged under para 15, prior to hearing of two rival groups or others, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. Now that's very important. So three elements in these notices, which according to me are completely contrary to the record. And they are aware of my letter, at paragraph 2, 2A. Sorry, 2B. Anil Desai by email forwarded 3 letters whereby it was mentioned that the following members have been judged in anti-party activities and have voluntarily given up membership of the party. Now, Commission can't decide that issue. So now let's go back to the last part, 702 that I was reading. Support claimed by them in organizational and legislative wings. Well, let's just pause here for a minute. Just reflect on what happened. The 30th of June, they were all sitting outside. There was no organizational wing. They were in Guwahati. They were sending letters from Guwahati that I throw you out, I am the person, I am the chief whip. Gogavli is the chief whip. Your person. Where was the organization? There was no organization. There was no activity in the organization. Evidence of support claimed by them in the organization. There was no support claimed by them in the organization until the 30th of June. Even after that, there was no support. It only comes later. Secondly, on the legislative wing, your lordship knows that the judgment said that has to be considered. So if the legislative wing, according to us, all 40 of them, are deemed to be disqualified, well, how will the election commission consider it on an even keel by virtue of proceeding under paragraph 15? The very foundation of it is lacking. You are presuming a foundation which doesn't exist. You are presuming that they are members of the Shiv Sena where they are voluntarily resigned. I have informed you about it. And you say we'll treat it as an even keel. Now, nobody disputes whether a big argument is made
about 324. Nobody disputes that power. Who disputes the plenary power of the Election Commission? Not I. We're talking about the interrelationship between proceedings under the 10th schedule and proceedings before the Election Commission to decide on symbols when one impacts the other. And the priority is whoever started proceedings first will be given priority in terms of decision making. If it is an afterthought, then after everything has happened and you have voluntarily given up membership of the party and thrown out an elected government, then you go to the Election Commission on the 19th of July and say, I am the party mother. Certainly the Election Commission can't get precedence. Now, as far as plenary power is concerned, and this is the last point I wish to make. Paragraph 15 deals with an admitted position that we are all members of the same party. That's how paragraph 15 came into existence in 1968. There was no question of 10th schedule. There was no question of election. And what used to happen, the history of litigation in this area would show that every faction used to throw out membership, members of the other faction. And obviously, Election Commission could not decide those issues. So they say, okay, let both factions come and we'll see who has the support. But that the foundation of that went away the moment the 10th schedule came. Then the question of factions didn't arise. Then the question of disqualification came. The purpose being that those who are disqualified cannot get the symbol of the party. Because they have voluntarily given up membership of the party. Otherwise, why have that? Why we have 2-1 at all? It is only a question of the legislature. Argument was this all relates to the legislature, that relates to the party. But then why have 2-1 at all? So paragraph 15 presupposes legitimacy in the context of membership of the party and two factions arising out of legitimate membership claiming to be that party. That is paragraph 15. Paragraph 15 doesn't allow the Election Commission to disregard what has happened under the 10th schedule. Because if it does, what will happen is, supposing your lordships decide in my favor, let's assume your lordship will decide in my favor ultimately in the petition, what will happen? They will say, we are the party. Now what's left in this matter? Can't turn the clock back. Election Commission has decided. So it makes my petition infectious. If our lordship decide against me and say, no, what happened was perfectly legal, in any case, they will get the symbol. So they are not in any case prejudiced. Why is it that we want this to go on today? When your lordships can decide this matter in October, here the matter decided. What is the great urgency today that this must go before the Election Commission so that the other freezes the symbol or gives it to somebody without having this matter decided? And then they say, look, my speaker is there. My speaker will decide. Well, how will the speaker decide? Because this court has said on the 29th of June that everything that has happened after 29th of June is subject to the orders of the court. They must have lost over. So how will the speaker decide that issue? And then the larger question is whether when they go to the deputy speaker that you are disqualified because we have moved a notice of removal against you, mother. The speaker said this hasn't come from any source at all. It has come from an email that I'm not even aware of. And it is rejected. And that fact is suppressed when they come to this court. And mothers, what's interesting is this court order. I'm sorry, mothers, I'm taking time. I didn't want to take too much time for your lordship. Well, let's see what the order of the court is on the 27th. Then show me careful. Well, it says, meanwhile,
as an intent, sorry. Yeah,
What is the date of the order?
date is the 27th of June.
PDF 2151.
2151.
Compilation of orders and proceedings is there in page C, Manas.
Thanks. Yeah.
Meanwhile, as an interim measure, because it's about a few paragraphs.
Yes, we've got that.
On
Yes,
page 3.
meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the Legislative Assembly to submit their written submissions up to today by 5:30 is extended to 12/7/2022. Correct, Malad? Now see your Koholo. Para 110. The argument is he gave us 2 days time. He gave us 2 days time. Natural justice. That's the argument. Therefore, this court extended. Now let's see the order. See pure Koholo. Para 110. Order is in the teeth of 5 the constitutional bench of this court. Then the government was offered. Then we came to court that look, the consequences of this is the government will topple. Then the judge said on 29th, but it is all subject to what we will decide. What does Kyoto say? I'll read it. No need for curiosity. In view of the limited scope of judicial review, it is available for para 6. And also having regard to the constitutional intentment of the status of the repository of the adjudicatory power, Speaker, Chairman, judicial review prior to the making of a decision by the Speaker, Chairman, and a legitimate action would not be permissible, nor would it be permissible at an interlocutory stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceeding. And such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. There is no power to interact the proceedings. It is only after the decision is taken that you can challenge it. That's the constitutional judgment. So where is the question of coming to court and saying you gave me only 2 days notice? Wait for the decision of the Speaker, you challenge it. The result was, because the court extended it for X number of days, the government toppled. And then we came to court and said, we said, in fact, I remember I had told the court that this is what's going to happen tomorrow, which is simple, why do you worry? We have passed an order saying everything is subject. Now they are saying it doesn't matter. And what is this inner party democracy? I have not understood. Inner party democracy in the context of 10th schedule means what? That you can topple any government you want to topple by joining hands to the opposition. It makes no difference. Inner party democracy is in the context where you are continuing to be a member of the party, not doing anti-party activity, and air your grievances within the forum of the party. Inner party democracy doesn't mean that you violate the 10th schedule and say I have the right to violate it, and this is inner party democracy. That's been given up. So this concept of inner party democracy by violating the 10th schedule, not going to the organization, staying in Ahmedabad and Guwahati, doing acts outside the house, and then going to the election commission on 19th of July when you've done what you had done and joined hands and formed government and will become a chief minister. And then you say that, look, as far as I am concerned, the election commission will now decide. Well, in fact, if this is the law, I think it bodes ill for the future of elected governments in this country. Thank you.
Thank you, Mr. Yes, Mr. Yes, Dr.
I'll give it in point form. What is the crux of the case? Or the nature of the phrase voluntarily giving up membership of the party. Whereas in actual practice, 90 if not 95% of acts or omissions coming under 21A relate to activities outside the house. by the very nature. 3 examples out of hundreds. Going and was bashing the party or abusing it outside. Going to a rival party and accompanying them for a topic. Indeed, going to the governor with a rival faction. Now, all of these have nothing to do with what you are doing inside the house. Voting or not voting in a trust vote, voting or not doing this, etc. A very important judgment of your lordships had occasion to consider it. I'm not able to find this. Ravi Nayak. Before I cited out 1994, supplementary to SCC 641. Ravi Nayak was said that, and this is practical, no person comes and says, I have defected. While it's being given to your lordships, kindly appreciate the nuance of this clause.
Speaker
Nobody will ever say, there is no case that says, I have done anti-party activities or I have defected.
He says speaker can infer.
The word is infer. The operative word on which Ravi Nayak is based is, it is inferred A and B by conduct. That's the heart of the principle. Just read para 11. Just that. Now, this I will read to save time from the middle. All of 11 is important, but just read first and middle practice. Middle of para 11. The said paragraph provides for disqualification of a member, they are talking of 2 of a house belonging to a political party, if he has voluntarily given up his membership of such political party, unquote. The words voluntarily given up his membership are not synonymous with resignation and have a wider connotation. Now, kindly read this. This is what I am relying on, but it's coming now. A person may voluntarily give up his membership of a political party even though he has not tendered his resignation from the membership of that party. Even in the absence of a formal resignation from membership, and inference, the operative word, can be drawn from the conduct, that's the second operative word, conduct, of a member that he has voluntarily given up membership of the political party to which he belongs. Now, fellas, if this is the law, then your lordships, fellas, has to consider, and not your lordships, fellas, the persona designata exclusively constitutionally entrusted with this power is one person, the speaker. That persona designata will have to consider no one else. What you did in Surat, what you did in Guwahati, what you did outside, good, bad, or indifferent, what you did with the governor, is directly Ravi Nayak. An inference can be drawn that you gave up. Now, if you gave up, then how do you operate clause 15 on the assumption that this is one faction of the party, this is another faction of the party? So, complete conceptual contradiction is my point number 1. And that is what is happening. Point number 2 is, your lordship may kindly read again to save time, I'll not read it, the 4th of August 22 order of this honorable court. The last 4 lines, and we all appeared in this, was based on a clear understanding at that time by that honorable bench that the election commission would not proceed. And the last 4 lines of that read like this. According to the learned senior counsel, that is Mr. Tata, it says so. The proceedings will take some time as voluminous evidence is usually submitted by the parties which must be considered by the EC. The learned senior counsel therefore states that no orders may need to be passed by this court interdicting proceedings before the election commission. In these circumstances, we grant liberty to the petitioner to file an application before the EC for seeking time. Such applications are filed 3 times. Time was given with consent. There is no formal order, no doubt, but this is endured from the 3rd week of July till today as we speak in October. September. That is point number 2. Point number 3 is what is the balance of convenience clearly endured for further 1 month. If this is endured already, it does not at all cause them irreversible. However, your lordships not protecting us causes us irreversible. That's point number 3. This point number 4. This ground of IAM, Your Lordship, I don't think should be catered by the form of an IA versus the substance of what we want. That's the simpler answer. But two more important answers for us in law. It would be, according to me, quite quaint. Your Lordship said that because it's an IA, your Lordship can't decide this matter, it's outside the scope of the main matter. But there is two other answers, factually wrong. Number one, we find several writs, including what your Lordship will call the all-encompassing writ, which is number 493 of 22 on 8th of July. Prior to that, your Lordship has 4 other writs in which this order of subject to outcome has also been passed. Prior. Election Commission is a subsequent development. It's as simple as that. It's a subsequent development. My writ 493 covers almost all the issues we have argued. 1 week, 10 days after the 8th of July, when I filed the writ, on 19th of July, this election commission is initiated. I have filed an IA saying that this is a subsequent development. Why your Lordship is hearing the main matter, please defer it. Because is that something so startling and beyond jurisdiction, like a fundamental lack of jurisdiction, that your Lordship cannot touch it? Therefore, that is, well, I hope, not their best argument. Now, Willis, one other thing, and I'm done. There is 2 paras of Rana very important. One, my learned friend Mr. Kaur read para 25. He did not read para 27, which is the following para after 1, which is very important. And the second para is 48. So these 2 paras I'll take 2 minutes on. My learned friend Mr. Kaur read the sentence to be very
Para 27 and 48.
Yes.
Just one moment. Let me go to grammar.
27 is the answer to 25. So then the context is placed in 27, which was has to be read.
Just give a moment. Page 192, right?
Yes. So my learned friend read para 25 and he read this sentence actually, virtually the sentence alone. Para classical C. The power to recognize a separate group in Parliament or Assembly may rest with the Speaker on the basis of the rules of business of the House. But that is different from saying that the power is available to him under the 10th schedule to the Constitution, independent of a claim, independent of a claim being determined by him that a member or number of members had incurred disqualification by defection. That's a sentence Mr. Kaur read. Now, the sentence which connects this is para 27 page later, where it is viewed as a continuum, as a part and parcel, and it is a continuum of split, merger, and disqualification. All are interconnected and have to decide by the Speaker. Can you read that? This is para 27 from classical D for Delhi. In that context, the Speaker cannot say that he will first decide whether there has been a split or merger. There are 2 concepts there. As an authority, and thereafter decide the question whether disqualification has been incurred by the members by way of a judicial adjudication sitting as a tribunal. Next sentence is crucial. It is part and parcel of his jurisdiction as a tribunal, while considering a claim for disqualification of a member or members, to decide that, but also in the context of the 3 raised by those who are subject, that they have not incurred split in the party or in view of a merger. It is part of one continuous process of the Speaker, who is a persona designata by the Constitution, no less. Now, while your worship is on this, just let me finish on 48 of the same judgment. Also, not be great. This is just 2 lines. This is just to correct, as one out of hundreds of examples, myriad examples which occur in 218 of voluntarily given up. This case involved a very specific case. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to an act of voluntarily giving up the membership of the party or to restrict the said members and party like. It is because all over the press and repeated that they went on this case with the other faction to the other party to the all admitted documents, all was on the record to the governor, doing exactly what Rana records in paragraph. My fifth point is that your lordship is cited first. I want to make a general fifth point and then tell your lordship. I make bold to say, and I've checked with Mr. Devdas Kawat, who is very meticulous of this subject. 10 times I've told him. Not one single case. I repeat, lordship recorded by submission. It's a rather broad thing, I don't want to make a note of it. Not one single case where the interaction and interplay between a disqualified or disqualifying pending matter in a symbols case. Not one case. I can't put it more widely than that, but I'm open to challenge on that. From that follows point number 6. One case is cited, which is Omar, etc. 1985, 4 SCC 628. Just note the citation I have not taken off, just note the difference. The only case cited is 1985, 4 SCC 628, where para 1 notes that this is a challenge to the constitutional validity. For one. Number 2, no issue arising in that case of disqualification. Now we have the 10th schedule. What was the 10th schedule in a descriptive manner saying now we have 10 schedules? That's para 10. That one para becomes the springboard, erroneously and wrongly, of citing that case, suggesting that there is an interaction between the symbols jurisdiction and disqualification. Nothing whatsoever. It's a completely inapplicable and irrelevant citation for this subject. May I end by saying, after thanking a lot for giving us time, that if the party, if there is, why, should kindly go back to the origin. Why did the 10th schedule use 2 broad words? Actually, this intra-house issue was the whip issue normally. Of course, it can apply beyond the house also. I'm not saying, but I'm saying that that was the focus. They deliberately and consciously used a very much wider concept. That concept falls directly in this issue to be decided one way or the other by the primary persona designata, the speaker's jurisdiction. It may or may not be briefly decided later on, but because the primary direct custodian of 10th schedule is only one person. As a matter of fact, there are problems sometimes the speaker is disqualified. Then the persona designata, they start doing hunting for a deputy speaker, which is strictly not legal. And then nobody there at all, then your lordship perhaps be interviewed. So therefore, your lordships will not short circuit this process. And no other procedure exists for deciding how to give a voluntary membership of party except what is here in 1A, which the speaker to his best ability decides. Today, in fact, your lordship is being asked to do 2 things by the other side. A, that this be decided first by the election commission. B,
what should be decided to this?
Decide it first is what your lordship is told. I will let the EC decide it first. B, is the nature of what is a political party minus them or with them will be decided first, and thereafter the nature of the party will decide by the state.
That's just one submission for your lordship's kind consideration. Only on Kyoto Holo.
No, it cannot be, Mr.
There should be a Kyoto Holo. Mr. Rejoinder was cited. Just one second.
1 sentence.
1 second. Perhaps Devoto Holohan said that while a show cause notice by a speaker is issued, no judicial review will lie till a final decision is taken. And that's why they're saying we ought not to have come at the stage when a notice was given to us on the 27th and when the order was passed. We came relying on Navam Rebia, which said the speaker cannot proceed with the matter. A constitution bench of this court had said the speaker will not initiate, continue, or proceed. So the issue was completely different, and their 32 is actually contrary to Kyoto because they are seeking this court to transfer all the jurisdiction of the speaker and decide it. And Mr. Sibal presumes that we are disqualified and the EC today cannot be approached.
All right. First issue. Yes. We have heard Mr. Kapil Sibal and Dr. Abhishek Singhi, then counsel appearing on behalf of the petitioners in support of the application for stay proceedings before the Election Commission. Mr. Neeraj Kishan Paul and Mr. Maninder Singh have appeared on behalf of the private contesting parties. Stop. Mr. Tushar Mehta, then Solicitor General has appeared on behalf of the Governor. Mr. Arun Detta, then Senior Counsel, has appeared on behalf of the Election Commission. Next. We've heard the. Sorry? Oh, yes, Mr. J.
What's you forgot me?
I'm so sorry.
No. Quite forget me.
No, not at all.
Apologies. Having heard the Learned Council, we direct that there shall be no stay of the proceedings before the Election Commission. The IA seeking stay shall accordingly stand dismissed.
Very grateful. Extremely grateful.
Is allowed.